Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Let's start our day with Judge Simpson. He's got his criminal docket going this morning.
Deanne.
Good morning, Your Honor. Christina Merrick, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Alexander.
Permission to practice is granted.
Thank you, Your Honor. Christina Merrick, two people.
All right.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Muhammad Jinan, who appears via Zoom from MDOC. Sir, could you please state your name for the court?
Do we have him?
So their camera was on. They are unmuted, but now their camera's on.
Muhammad Deanne?
Yeah.
I don't have a photo. I don't have a picture.
He is on. And he is.
Mr. Deanne, if you can hear me, please state your name. I don't have a photo. I'm blank.
Yeah, I can see now.
I'm going to pass that matter.
Thank you, Your Honor.
Court does call the case of the people versus William Parker.
And then on behalf of the people, Your Honor.
Yeah, good morning, Tom Piotrowski, P40021 on behalf of Mr. Parker, who is in court today, standing to my right. Mr. Parker, identify yourself, please. Yep, my name is William Parker.
All right. What are we doing?
We are pleading per the people's offer of operating while visibly impaired second, with the understanding that Mr. Parker will be going into sobriety court as well.
So he's pleading to an added count to operating while visibly impaired second.
Yes, sir.
Correct.
Do I have a plea form?
Yes, sir, you do. Along with the advice of rights.
So the advice of rights, I just. Got it. You see, it was turning the other way. All right. Court's understanding is he's going to be pleading guilty to the charge of operating while visibly impaired second offense, a 1-year offense. Upon a successful plea to that charge, count one would be court's full under.
Yes, sir.
May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, have you got?
Yes.
Lower and then state and then spell your name on
Yeah, William Parker, WILLIAM and PARKER.
All right. Sir, this is court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you?
I'm sorry.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not currently, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of February 5th, 2025, at the location of, and I've got the Carpenter Road in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 4 drinks and 1 shot, Your Honor.
Okay, 4 drinks of.
Beer.
All right. Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
They said I was weaving a little bit.
Okay. Are you disputing at all or contesting the right of the police to stop you in this case?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital for a blood draw?
Yes, I was.
All right. And what were the results of that blood draw?
I think it was 0.12.
We'd stipulate to that, Your Honor.
0.129.
0.129. Yes.
And so you have no reason to dispute those blood test results?
No.
All right. And sir, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. And prior to that date, on or about October 19th, 2022, in the 48th District Court, had you been convicted of operating while visibly impaired?
Yes, Your Honor.
All right. Sir, before I accept your plea, I do have to advise you that if I accept your plea between the time of today and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any evaluation or sentencing recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir. No, sir.
Have I complied with the court rule, and would it be proper to accept this defendant?
Yes, sir.
Yes, Your Honor.
All right, court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be. Is he trying to get into a sobriety course?
Yes, and he already has been assessed, Your Honor, by Crystal Rays.
So 14B.
Yes, sir.
All right. Talk to probation as to how they want to handle that. Sentencing in this matter will be
August 27th at 12 p.m.
August 27th, 2025,
Can
12.
we make it the following week?
I don't have sentencing the following week. What's the September 10th? Would
Yes, sir. Thank you.
that work?
Yes, sir. It's 9/10, September 10th.
September 10th, 2025, 9 a.m.
Yes, sir.
Bond with its conditions will continue.
Thank you, sir.
Thank you.
Thank you.
Court does call the case of the people versus Aline Wood.
Wood?
Ellie said on behalf of the people, Your Honor.
Good morning once again. Tom Pietrowski on behalf of Mrs. Wood. Mrs. Wood, if you would identify yourself, please, and state your name.
My name is Aileen Jane Wood.
All right, what are we doing?
I've
This
had,
is an arraignment.
I think, pretty sure she may have been already arraigned and maybe not. We'd waive arraignment if so.
Wait, formal reading to stand mute.
Yes, sir.
Defendant having waived formal reading, standing mute, court will enter not guilty plea.
We're in contact with Miss Londy. We're trying to resolve this, and also we're waiting for additional discovery, some medical records that I've requested. So we just ask for an adjournment, Your Honor.
It's 6, right?
Excuse me?
Yes. All right. Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to
September 3rd.
Can we have it on the 10th as the other cases, Your Honor, or not? No? Okay. September 3rd it is.
Pretrial will be adjourned September 3rd, 2025, 9 a.m. Or as your invite indicates, as to bond in this case,
Would ask for a personal.
set the defendant's bond as a personal recognizance $5,000 bond. There is, I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's no use of alcohol, recreational marijuana, or any illegal drugs. That's all I'll do at this point.
Thank you, sir.
Thank you. Court does call the case, people versus Jason Elk.
Ellie said on behalf of the people, Your Honor.
May have pronounced that wrong. Now get Mr. Diane back.
I have not heard from the facility yet, but I did.
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside defendant Jason Eckel. Mr. Eckel, would you please state your full name for the record?
Jason Michael Eckel.
As to the arraignment,
Your Honor, for purposes of the arraignment, having had the opportunity to discuss the matter at length with Mr. Eckel, we are prepared to waive a formal reading of the complaint. Mr. Eckel will stand mute. We ask the court to enter a plea of not guilty.
defendant never waived formal reading, standing mute. Court will enter a not guilty plea at this time. What are you requesting I do with this?
Your Honor, for purposes of pretrial, we would be asking the court to set a pretrial date in this matter to give opportunity to further engage in due diligence and discussions with the prosecutor's office in an effort to resolve the matter.
Pretrial in this matter will be adjourned to
September 3rd.
September 3rd, 2025, 9 a.m. As to bond in this case, alleged BAC.
I have in my notes as a 0.09.
Are there other
0.09 and then a 0.10 after on the chemical. So 0.10.
point one? And this is the second offense.
Correct, Your Honor, there was a 2021 prior.
Any accident?
No crash in this case, Your Honor.
No injuries either, Your Honor.
Set the defendant's bond, $10,000 personal cognizance bond. All other standard conditions, including no assault behavior, possession of any weapons. You are now at this time not to possess or consume any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, Your Honor.
I am also going to order that he report over to the Department of Community Corrections for placement on a SoberLink testing device. And I've signed that order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Janine Kruger.
Sally's end on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Ms. Kruger. Ms. Kruger, unmute and state your name, please.
Janine Kruger.
Okay.
Your Honor, in this case, we adjourned to today so that the people could reach out to the complainant to see if some of the references in the police report are still true about a desire to proceed. That is not resolved yet. So we're asking to adjourn the pretrial one more time.
You're in pretrial in this matter, September 3rd, 2025, 9 a.m. Bond will continue. All right. Thank you. Court does call the case of people versus Jillian Satori.
Sally's end on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Ms. Sartori. Your Honor, state your name, Jillian. I'm sorry.
Jillian Sartori.
Thank you.
We're here for a couple of reasons. One is to address the bond violation. The court wanted levels. The parties didn't get the published levels that I think the court has in the court file. But from my understanding, she is in fact coming down on her THC levels.
Yeah, kind of. I think this is the one that I was thinking of. I think what happened is he went. My last one. It's just the last one.
Okay.
They're backwards. Got him. Yeah, she went up and then decided to come down. So she is coming down.
Well, Your Honor, we don't have what you have, but she's been very adamant that she's been following your orders. So,
All right.
And the other thing is Ms. Lonnie was not prepared to make a resolution until we knew that answer. So we're going to ask the court adjourn this pretrial, but maybe we approach on one other thing real quickly.
Very quickly.
Thank you. I don't move too good today.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Well, he's muted. Let's stay in Michigan, but we'll head slightly southwest and see what's going on with Judge Anzalone.
Okay, I'm sorry. Go back and have a seat. I was really trying to get your case done. If you got to be there at 10:30.
Yeah, I tried calling him. Oh.
No, if Mr. Millar doesn't get here by 9:30, I'll just adjourn it. Okay, don't worry. Okay, because it takes about an hour to get there. All right, I'm gonna put that back. Let's try. All right, Ms. Wright, I am back to you. So, Mr. Murphy. All right, so we're back on the record in the matter of the people of the state of Michigan versus Erica Wright. File number 25-22217FH. I have Isaac Sneed appearing on behalf of the people and Matthew Murphy appearing on behalf of Ms. Wright. Ms. Wright, I do have a letter from Darren Coast, who is my pretrial services coordinator, states Ms. Wright was completely negative on 7/7/25, positive for hydrocodone on 7/14/25. She was required to test on July 21 and she failed the show. She had a heart procedure done on 7/22/25 and we have not heard from her since. Ms. Wright, are you at home?
Yes, I am.
Okay. Are you still living in Milan?
Yes.
Okay, so Mr. Murphy, how do you wish to proceed today on Ms. Wright?
Your Honor, I was going to ask if we could adjourn. I want to talk with the prosecutor more about the offer. Right now, it would involve her going in a drug court, and I wanted to talk about that requirement. I don't think the case is extremely old. She was in.
So she lives in Milan. She can't be in our recovery court.
Yes, that's why I need to talk with the prosecutor about what we want to do moving forward. So I wanted to adjourn if we could just one more time and have the case resolved by then.
All right, so Mr. Coast, she is still not tested with you?
She has not, Judge, not since July 14th. I'd obviously like for her to test today.
All right, so Ms. Wright, I need you to test today. You have 2 contempts of already, one for failure to appear for contempt on May 21/25. So I'm going to order that you come test with Mr. Coast today. And if you do not show up today by 3 o'clock, I will issue a bench warrant. Do you understand that, Ms. Wright?
Yes, I do. There's no way that I can get there, though. I mean, there's no possible way that I can get there. I'm just got home from the hospital on Sunday from having heart surgery, and I can't even barely move.
All right. Did you provide documentation of your surgery to your attorney or Mr. Coast?
No, but I can. I mean, if it needs to be, I can fax it over or something. But I mean, no, I have not. I mean,
okay. Mr. Coast?
Judge, if I could get a breakout session with her and I could let her know how she could get that documentation to me. If that's the case, I'm okay putting that off until Friday as far as testing.
All right, you're gonna have to test this week, Ms. Wright. So whether you do it there or you do it here, you're gonna have to figure it out. So I'm gonna set a pretrial for September 3rd of 2025. Mr. Murphy, you can do the stip in order to adjourn. And Mr. Coast and Ms. Wright, I'm gonna open up a breakout room. And just a second.
Can I replace in there too, Your Honor?
Say it again.
Could I go in that breakout room too, Your Honor?
Sure. So I have Mr. Murphy. Yeah. Hold on, Erica. I'm trying to find you in my break. Mr. Murphy. There you go. All right, I've opened the breakout room. Mr. Casper, I need to take care of Miss Clough because she needs to go.
Let's switch it up. Let's go to Texas. Judge Stevens is getting his day started.
Yes, sir. Okay. You were charged with state jail felony of evading arrest or detention. You have, though, 2 prior convictions out of this court back to 24 years ago for controlled substances, state jail felonies, 2 other state jail felonies. That brings that up, I believe, to a state jail felony punished as though it were a 3rd-degree felony. Everybody's looking at me like, I can't believe it's not butter.
I'm not sure it's state jail felonies. So
It makes it 13.
yes.
Is that your final answer? I think that's, you did this yesterday.
Yes, sir.
And that's what we figured out yesterday, same thing. So it's punished as a third degree felon because of your prior convictions, which is the equation in criminal law. The crime, the circumstances of the crime you're charged with, and criminal history work together in determining what a sentence is. So that means you're looking at up to 10 years in prison. Okay. What are we gonna do?
So change me. Exact time to go.
Anything else we need to bring up here?
Oh, you're on.
On this, get it resetting, for court is easy. Devin Westbrook. Devin Westbrook, please, come on.
Oh, here's not.
Hmm.
You have to fill out everything, even if this is.
How old are you? How old are you, sir?
I'm 17.
17. You're looking at life imprisonment right now. You know that?
It's not as well. I'm sorry. Everything has to be, they'll have to go legit.
All right. So that sinks in. You understand everything is serious in this room. Some are more serious than others. What are we going to do today?
Fresh parking. You still have work on the information and the documents true and correct. Highlighted, I checked their plan.
Doesn't say anybody on. He turned 17 a month before he's alleged to have committed this offense. Well, that's rare that we have some money.
Yep.
You just turned 17. You're treated as an adult when you turn 17 in Texas. I mean, you didn't make it long as an adult, 17, before you've gotten yourself into a lot of trouble. Life in prison means at least 30 years of your life, 30 at least. And something, I guess, where a firearm is used, according to this indictment, you can't get parole until you serve at least one half of a sentence. Were you ever in any trouble before this? Do you? A lot? No, but okay, but what happened? You know, what you knew mistakes have consequences. Did you learn from those mistakes? Okay, well, maybe this is fixable. You're presumed innocent. That's the important thing. But the grand jury has indicted you, which means they have probable cause. I'm playing the scales of justice. Probable cause to believe that you committed this crime. And jurors in this county are pretty serious when it comes to violent crimes, no matter what age. The wise thing to do is follow the rules and not get involved in behavior that could result in a crime. But here you are. Now, what are you going to do to try to fix this? Work with her. Yes. Your attorney, Ms. McNally. Okay. This is, you're going to want at least 4 weeks.
Yes, Judge.
Okay. I'm going to reset this for 4 weeks. With your parents? Okay. Anything else
No.
in this? Okay. Does he have his paperwork done for? Go right there. Christopher Allen?
Okay, everything happens to go, even if it's zero, you have to write zero, okay?
You're on this one.
Yes.
Come on now. You are Christopher Lee Allen. Okay, in 25 CR 429, You are charged with the third-degree felony of unlawful possession of a firearm by being a convicted felon. But it doesn't stop there. It says that you were convicted out of Harris County in 2023 for unauthorized use of a motor vehicle. And Washington. Then thereafter, on February 2nd of this year, it's alleged that you committed this offense of unlawful possession of a firearm, which is a third-degree felony, carries with it up to 10 years in prison. But paragraphs 2, 3, and 4 allege that you were convicted for 3 offenses in this court in 2019, aggravated assaults, 3 aggravated assaults. And so if that's proven true and you're convicted of this offense in paragraph 1, this unlawful possession of a firearm by a felon, punishment range bumps up to a second-degree felony punishment range. So you're really looking, if this is true, up to 20 years in prison. And serious. So we got to treat it seriously. Best thing to do is avoid committing crimes. This is initial.
Yes, I'm still waiting on this media. I need 4 weeks.
Bet you need 4 weeks.
I do. Be safe bet.
Do you still live in Morgan City?
Yes, sir.
Okay. Well, where are you? Because we got to keep up with you here. Your address.
My new address will be 3444 25th Street.
3444.
25th Street, Port Arthur, Texas. 77642.
Who do you live with there?
My father's.
Your dad? Okay. You also need to know under the law, because you have previously been convicted of a felony offense, you are ineligible for probation in front of a jury in Texas. You understand? That's full code. So you're looking at straight time unless a deal was struck. The only courts, the judges can grant a form of probation under your circumstance, which is why it's a good idea not to get in trouble. All right, get a resetting. Hey, Langston.
I'm signing up.
Jasmine?
Right now.
Jasmine?
Jasmine TCF.
Oh, no,
And probably there was gonna be a plea.
Yeah, he was a no-show, and so his bond was revoked. So, yeah,
Okay.
it was double.
Yes.
This is.
I'm gonna need all of them.
Do you want?
Jasmine,
Stack.
yeah, give me.
Okay, here's the first.
Okay,
Handful.
thanks. Okay. 25 CR 364 is called the State of Texas versus Jasmine Dudley. Dudley?
Yes.
Present with Mr. Adams, your attorney and the state's attorney, and
Judge, on her case.
on her case. Yeah, wait.
This is what free, that is.
May concern.
That's Samantha Instock, counselor, psychologist.
Hold on.
Also.
Mr. Boyd, you need to be up here on this, please. You- Yeah. Grand Central Station.
Yes, sir. Always is.
Jefferson County, Texas.
Yep. And I have a copy of the same thing for the state as well. I did some, I made two copies.
He's giving us papers, homework assignment.
Homework assignment. No, just on the, what happened was,
Hey, what is this? This sounds great. What does this have to do with though guilt or innocence?
what I did was I filed a motion to have her tested based on her side. It's my position that on the date of this offense, she was totally not in the right mind, and she's been under psychological treatment, and she's had mental disorders. I ended up getting the medical records, and that's why I gave you a copy of that, and I have medical records too, if you want to go through them. I just wanted her to get tested by Mr. Capone, Dr. Capone, I should say. Because I don't think she had a clue of what was going on that day.
Well, you don't know.
That's what I think. I don't know. I mean, that's what
Has she ever been diagnosed as being incompetent? Or
she's saying yes. I don't know. He's saying
who tested you and deemed you to be incompetent?
Yeah, this operation.
When?
2016.
For why were you there? Were you charged with a crime?
No.
Well, that's what we check for competency for. They wouldn't be checking for competency unless you were charged with a crime, man. So that you didn't understand. But you were in Baptist hospitals? Have you gotten those?
those are she back
Records? That what these are?
I believe. Yes, sir. I just printed those last night.
Well,
and that's what they were. You should also have worked with AC years. Those are the hospital outside. Yeah. I did finish trial of the judge office recently where I was asked. Judge, this is a cycle. You can't tell the same one of the back of the gun. This is bad. This is bad. That's like the future is very bad for eating.
this thing got, did you see how it got printed? Got printed,
Yeah.
vertically, not horizontal. Weird. Well, there's a lot of pages.
Yes. If that's
While the court is deep in thought analyzing the documents in front of them, I would like to direct your attention to the pinned chat where there is a link to our bingo game, TCF Bingo. If you're not already playing, give it a try. Long story short, there's a bingo card. It's based around what happens in court, and it's a good, fun way to interact and, enjoy yourself a little bit as you watch the show. Let's go back to Judge.
I can show you something real quick to kind of help you fast.
I think I've gotten to it. Recently, she reports inconsistent Lexapro intake due to running out of medication, then using her grandmother's medication and to compensate. That's what you said. Don't act like I can't believe it's not butter. That's what you told the people at the hospital. Which is what you sent to them. Well, they didn't have to, they don't make that stuff up. They just relate directly what you tell them. The thing what she appeared when she spit on the lady, she appeared intoxicated, they say, according to this. Question is, what happened when she was arrested? Did they still send her to the hospital for a blood test or something? That would be important for all of us to know.
Yes. And on the date of this offense, she had prison cell phone. And that's situation. If you need it, I mean, I got it.
Did you have copies?
I got copies. Oh, you can use it. You have it. But I know that, and this is what I was going to show you real quick.
Would you do something? I'm going to send, we're going to get her to Dr. Gopal. Can you follow that up with something in writing?
Yeah, I did. I filed a motion. I already did. Here's my copies of it. I followed it already. Yes, sir.
Okay, it's not in here.
I followed it. I followed it.
Okay, but we'll do it.
Yeah, that was it right there. I followed it. What's my receipt showing? I followed it.
Okay, did you have a copy of it?
No.
Okay, all right.
But I followed it.
All right, we'll
Thank
look
you.
for it. If we can't find it, we'll get back with you, but we will get her to Dr. Gopal for an evaluation on this too.
Thank you, Judge.
Okay, reset 6 weeks, okay?
That's perfect.
Okay.
He does the doctor.
Next is Kara Quibitt.
That's a plea. I'm doing the paperwork now. You want me to?
Finish it, yeah.
Okay.
Down the holiday.
We have 3 cases, right?
Yes, they all gonna be disposed of today.
Good working.
Let me get this.
Okay, thank you. Adam Dixon. Thomas,
I need to talk to the prosecutor. I think it's set to.
this is a plea hearing.
Yeah, to write something up.
Melvin Espinal, Mr. Crenshaw.
Your Honor, that's a plea. If we could come back in 30 days, it would be a plea for time. He's gonna.
Where is Mr. Espinal?
He's right there in that suit, Judge.
Okay, you're doing something else?
No, I'm working on another client.
Okay, why don't we take care of this one and move him on?
Yes.
Okay, come on up.
Come on, no. It's okay. We're working. We're going to. Well dressed. I client out the court today, Judge.
Really nice.
Prosecution.
Yeah.
I'll give us any consideration.
You know what? I'm in. On Mr. Espinal is down. I don't have that. Here.
It's right here.
23 CR 440 is now called. You are Melvin Espinal with Mr. Crenshaw, your attorney. You're charged, of course, with third-degree felony of operating a motor vehicle in a public place while intoxicated.
And Judge, we have a resolution for 3 years TDC, and we can just reset it and actually get his affairs in order. We'll be ready to do this. He's had an analog device now for almost 3 years. He hasn't had any problems.
He has one.
Hasn't had any problems with the analog device for 3 years, is getting medical treatment for his alcohol issues.
Yeah, what about that? Because this is your sixth DWI as a felony, right?
Yeah.
Yeah, which meant you must have had 2 before that. 8.
No.
This is,
He's has 5.
5 felony convictions.
No, you're not.
This is 2, these are all,
That's not accurate.
that's not. Oh, here's county criminal court in Harris County in 09.
This is number 5.
But still, 5's too many, right?
Understood.
What are you doing to fix this?
He's on a prescription. What's that prescription called?
Trexon?
Next Trexon.
Put their taking these. Yes, graduates, colleges.
Yeah, we're putting the restitution. Basically during 30 days later.
He's got a great job. He's got a new wife.
Got things to lose here by making mistakes,
We
right?
try to get probation judge with the state wants to do contempt, which we understand considering the facts and circumstances.
Yeah, these are,
This little farm right here.
you gotta, remember, the DWI is a kind of a selfish thing because we're out there with everybody else driving these 4,000-pound missiles around town. They can do a lot of damage when they run into each other. That's why you have to operate those things responsibly.
Just feel with that decision, it's just.
Are you gonna fix this?
Absolutely, yes, sir.
When it's not-
I think 30, 45 days. She was going to get us
6 weeks, go ahead. Okay.
Thank you, Judge.
Yeah. Jerry Hanley.
Yes, that's up to the judge. We're doing the paperwork right now.
Okay.
Oh, got it. And then the last client.
Jerry Hanley. I've got Jerry Hanley on 2 cases.
Oh, 2 cases, yes, Judge. That's be a resolution.
Cody.
Both cases. Cody Hatch is right here. Come on, Cody. Judge, that's not a resolution today. I'm optimistic this would
Mr.
be
Hatch.
a dismissal or reduction. This was Mr. Ekmar case, and Mike just needs some time to do a little research and come to his senses.
Have you ever sensitive?
Have you ever known me to come to my senses, Judge?
You say a little time?
Just a little time.
Here, I'm 11 years, I don't think I've come.
You're Mr. Hatch?
Yes, sir.
As you know, here you're charged in 23 CR 1093 with third-degree felony of operating a motor vehicle in a public place while intoxicated. So you're looking at up to 10 years in prison. So this is serious, and it should be. You heard what I said. The one to the person before you. Are you still here in Port Neches?
Yes, sir.
I pretty much grew up with my cousins on Merriman in Port Neches. I grew up in Groves, but my cousins who were my age We're on Merriman Street. And it's interesting. There's a Marion and a Merriman.
Yeah, well, that
And
can
that
be
fit.
confusing.
It can be. I'm wondering how much is going in different places because of that. Okay, how much time?
Judge, if we could just do a standard reset on this for the
There's
6
nothing
weeks.
standard in this room.
Yes.
Yeah, 5 weeks.
6. would be
6, good.
preferred.
Couldn't settle out of court there on that one. 6 weeks. You gotta be setting.
Yes, sir. Thank you. Good to see you. Thank you, man. Yes, sir.
Wayland Levens is another one.
That was reset.
It's not, well, it is.
Washington, Washington.
Hey, so, you've got, there's Wayland Levens on this, Matthew Sharp, Mary.
Those are all my
And
cases that weren't more than
Justin
10 days
Walton.
old, reset, Judge.
Okay, they showed up on this one. Oh, all of these are off the chart, right?
Correct.
Wayland Levens, okay, that's.
You can call all my cases except for what I'll share with Mr. Burns.
Van Meter
Thank you.
and Walker.
Yes.
Okay. Yesenia Alvarez.
That's mine, Judge. We just need some additional time. That's a DWI case, sheet president.
Alvarez.
6 weeks, please.
Raise your right hand and swear or affirm to the truth or truth and nothing but the truth, so help you God. You got to the little right thumb, please. Place it flat on the wall. But one more time, I need a little bit darker. Okay. Right here. Have a seat for the call you in a little.
Yesenia Alvarez. Don't need to, like the rest of these, for
You just hold back.
down, just do this style.
Okay, who are we looking for?
Yesenia Alvarez, Yesenia, yeah.
Yes.
All of those, a bunch of those need, okay. Hatch, Cody Hatch,
We did
William
that.
Levens, Matthew Sharp, Van Meter, and Walker all have been reset.
Okay.
So we don't need that.
Yeah.
I need whatever's after this one.
You want the whole stack?
Yes. Okay, you just get it started. Oh, in this one. What am I doing? Oh. okay. 25 CR 348, you were charged with a state jail felony of operating a motor vehicle in a public place with a child while intoxicated. So you're looking at a state jail felony, which carries with it up to 2 years in the state jail. So it's serious. And today we're going to do what?
We're just asking for additional time.
How much?
Would be maybe 6 weeks, Judge.
6.
Yes, please.
Did you already go on your trip? Are you going? Okay. Next one. Get a resetting. Be careful driving, ma'am. You know what I mean? You know what I mean? Okay, Luke.
Judge, I'm working out some paperwork for. So we're dealing with it right now.
Oh, hold on, Kevin Romero.
Judge, yeah, he's present.
Come on up.
Mr. Crenshaw and I are on that.
Oh, we got our best men on the job.
Right. So
Remember that commercial? Yeah, I got my best men working on it and they're all laying on the car.
Yeah.
Sleeping. Yeah. How's my car? Repair. Oh, I got 2 of my best men on it. And then the camera shows they're sleeping on the hood. Yeah, go ahead. That's not applicable.
Not what we're doing here.
I just remember that as a funny commercial.
Judge, we're waiting on some medical records. This is a case.
Okay,
that-
you need some additional time and your name again is Ramirez?
Yes, Ramirez.
This is Mr. Ramirez?
Yes. But probably 8 weeks on this because it's just taking a little long to get the records that we need.
All right, 2 months.
Have you graduated yet? Yes, sir. Okay.
I was gonna ask you that, Corey.
Has he graduated?
Yes.
No, not yet, Judge.
What's your joke about graduating?
Highlighted it.
Similar to law or something? Don't you have a?
Yeah.
Don't you have a corny joke about that?
Yes.
Yes, he does.
Yeah, yeah,
Please tell us.
my family, all graduated magna cum laude. I graduated laude. How come? It was a different kind of an award. It was a different kind of award.
So speaking of dad jokes, Judge Stevens getting his in. So we haven't done animal nature stuff in a couple of days. Today I've got my eye on this goat farm. This is Simon Says Farms, so this feed is courtesy of them. Bunch of goats, a few babies moving around in there. They look pretty happy this morning, so we'll keep an eye on them. Let's go to the great state of Louisiana and see what's going on there.
Orders of the Department of Corrections. To my left is Carolyn Stapleton. To my right is Jerry Ledoux, and my name is Steve Prater. The time is 8:38 in the morning. The date is August the 6th of 2025. We'll be having a number of hearings today. This will be our first one. This is a revocation hearing. Would the staff here introduce themselves, please?
Sure.
Okay. And on this revocation hearing, we have a fellow by the name of Anthony Kenner Jr. Are you Mr. Kenner?
Yes, sir.
And what is your DLC number, Mr. Kenner?
447501.
Okay. And you are at St. Charles Nelson Correctional Center. Is that correct?
Yes, sir.
And is there any staff in the room with you?
Yes, sir.
Would you introduce yourselves, please?
Lieutenant Ball.
Okay, Lieutenant, thank you.
You're welcome.
Okay, anybody else in there?
We also have Corporal Stallworth.
Okay. Corporal, thank y'all for hosting us today, and I think this is our only hearing there.
Yes, sir.
And so we'll get straight to it. Mr. Kenner, did you have a waiver? Okay, can you hear me okay? Okay, Mr. Kenner, can you hear?
Yes, sir.
All right, do you have a waiver in front of you?
Yes, sir.
Okay, and that waiver talks about your attorney and all, and did you sign that waiver?
Yes, sir.
Okay, so we're going to proceed with your hearing today. You are accused of violating two rules, rule number 4 and rule number 5. Rule number 4 may have been dropped, but they're very similar. Rule number 5 is the one that we're going to deal with this morning mainly, and it has to do with a vehicle chase or a vehicle stop, and you supposedly fleeing from that stop and running behind the house and throwing a gun. Is that correct? Is that what the rule, is that what you're accused of violating?
Yeah, that's what I was accused of violating, yeah.
Okay, so you need to plead guilty or innocent on rule number 5. Then let's start out. You are guilty of having been arrested for that, correct?
Yeah, I'm guilty for being arrested for it.
Okay. Now, are you guilty of having done it?
No, sir. I went to trial in the federal court, and I was proven not guilty by unanimous decision by the jury, which is all 12 said I was not guilty due to the evidence.
Correct. I understand that. And we are not bound by the same rules. We have to determine if we feel like that you're other circumstances. I won't get into a lot of detail about that. Okay, tell me about that. Tell me about that day if you'd like to, and make a statement, whatever your statement's in, so we can decide, make our decision.
Okay, the same detectives, the same statement that they gave at my hearing,
right?
The complete opposite from the statement they got on the stand and said, which was a complete opposite from the statement on the police report. They gave several different reports, several different statements. All of them contradicted each other. My lawyer, the jury, all seen it. They all made up different stories, and it was proven in trial that I was innocent.
Okay. All right. I have a question about this. You know you're not supposed to be around guns.
I know
A detective, according, and all we have is the reports of what happened.
Okay.
And the fact, we do have the fact that you were found innocent by the federal, by a federal jury, but the gun that you're supposed to have had, that the detectives with St. Charles Sheriff's Office say in the report that they saw you throw down, and it was behind the house where you ran. Tell me, how did that get your DNA on it? You read the reports, I'm sure, and during the trial, DNA evidence. Correct?
Yeah, it never once said it was my DNA. If you read the report correctly, it never said it was a match of my DNA. It never said that. It's the only thing it said it was a positive match for was a male. It never said it was a match for Anthony Kenner's DNA. It could be somebody on my same blood type or anything to say it was my DNA. My fingerprints wasn't on his gun. And it's also the same detectives who I'm on parole for, the same narcotic agency that don't want me on the streets. I was just released from jail. It's obvious they don't want me on the streets.
Okay, according to what the report says, assuming a mixture of two individuals, the DNA was found on the gun. This mixture obtained is at least 360 quadrillion, which is a big number.
I understand.
Times more likely to be observed if it originated from Anthony Kenner Jr. and one unknown unrelated individual than if from two unknown unrelated individuals.
And
in other words, I mean, how do you explain that's quite
the best way I could explain it the same way my lawyer explained it. If it was my DNA, it would say it was Anthony Kenner's DNA. That's the purpose of a DNA test. That's the same thing my lawyer explained to the jury. Same thing my lawyer told when I was in trial. If it was Anthony Kenner's DNA, it would say it was Anthony Kenner's DNA. It wouldn't be no mixed up. It could be somebody on my same blood type, and it'll say it was the same type of DNA. It would say Anthony Kenner's DNA if it was my DNA.
No, so we're not talking blood type. We're talking 360 quadrillion times more chance that it's you than someone else.
I know, but what I'm trying to say is, if you take a DNA sample to do DNA analysis, if it was my DNA, it'll say 100% match. It wouldn't be a mix up, or it could be my DNA. If you take a DNA of yourself right now, and it'll say, okay, it's your DNA. It wouldn't say it could be or it's possibility. Same way my lawyer explained it in trial. That's why I was proven not guilty by 12 jurors.
Yes, well, I understand that.
And I also been in jail 18 months now with fraud. All the evidence is fraudulent. I've been in jail 18 months with fraudulent evidence. I was proven not guilty on every charge they locked me up for.
Okay. I'm looking, are you reading a letter from the DA by chance? Or the judge that mentions the quadrillion again? 360 quadrillion.
If I'm sure if that evidence was sophisticated or strong enough, I would have got found guilty.
No,
wouldn't be a question about that. If it was my DNA.
What they decide and what we decide, whether you're in proximity, are two different things.
I understand that, sir. I understand
that. Do you have any questions? You have any questions?
I don't.
Okay, you have anything else you want to say about that?
No, I just wanted to say that I've been in here 18 months now. And it's been fraudulent evidence from day one. It's the same narcotic agency that I'm on parole for. The same detectives that I'm on parole for that was involved with this right here. And if the evidence was strong enough to prove that I was guilty, I would have been found guilty. I've been in jail now 18 months with no evidence. That's all I'm saying. If it was my DNA, it'll say it's my DNA. It wouldn't say liability or it could be or it's possible. It'll say it's Anthony Kenner's DNA. That's the whole point of a DNA analysis. Thank you.
Okay. All right. Well, I think that I'm trying to find this letter right quick. If you just give me just a second. I had it marked on here and
So I'll ask a question. Well,
I think I've got it right.
Mr. Kenner, you were paroled in November of 2023, and this happened in February. Did you report?
Yeah.
And, did you paid your fees and everything?
Everything
Were
I
you,
was supposed to do, I done.
were you employed?
When we was detained, if I was able to bring that to the table, we was coming from filling out application at ADM, Aim Grain Elevator. We was en route from Grain Elevator when we was stopped by the police illegally. That's
How
another
many-
thing that happened illegally. They had no probable cause to even stop us.
How many people were with you when you were stopped?
One,
And where's the other person that was involved in this? They never got charged with anything.
no, they got charged with traffic.
Okay, is there anything else that you would like to add? Okay, I believe that we're through asking questions. You're through with your statement, so it's time for us to vote. My vote, since I'm the one that was assigned to the case, and it takes 2 out of 3 votes to decide if you're to be revoked or not. But my particular vote, I believe that DNA, when you're talking about that many quadrillion chances of it being yours, I believe the gun was yours. I think you ran back there. I believe that the detective saw you throw it. It wasn't just one, it was 2. The gun was found right there where you ran. My vote is that you be revoked.
Excuse me. The same detectives got on the stand at my trial and said they didn't
Yes,
see me
sir.
throw a gun.
Yes, sir. Voting now, so.
Okay,
Oh, I'm sorry.
I concur with Mr. Prater that you should be revoked.
My vote is to do not revoke, to send you to a transitional work program for a period of 6 months. You were not found guilty and you've been in 18 months, so that would be my vote.
Okay, you, as of this morning at 8:49, you had 2 out of 3 decided to revoke you, and so therefore your parole is revoked at 8:49. Thank you.
Denied.
I have a lot to say on this matter, but I don't know where to say it. We'll discuss it. Maybe this is something that we talk about on sidebar. Maybe this is something that I talk about in a pre-show, but I think this needs to be fleshed out more. And yeah, as Ashley just said, rewatch. I want to watch it again to make sure I've got all of the specifics on it correct in my brain. Because I was immediately set off when they asked him if he was guilty of being arrested. Arrest is not a guilt or an innocence matter in and of itself. It's a matter of there was probable cause to detain you and arrest you. There's a lot going on here. More to follow, I think, either in sidebar or on the pre-show. Let's go back to Judge Simpson.
Next available date is after the 3rd of September.
After the 3rd. September 17th.
That would be wonderful.
2025, 9 a.m., or as your invite indicates. Alleged BAC in this matter?
Your Honor, it was a .129.
Okay. He has a prior on this.
He had it first a couple of years ago, so.
And the prior was 2021, Your Honor.
Got it.
So it has to be released in the PR bond. I know you're gonna order SoberLink and he would be fine with that.
Bond will be set in the amount of a $15,000 personal recognizance bond, all other standard conditions, including no assault to behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You are to report over to the Department of Community Corrections for placement on a SoberLink testing device. Thank you.
Right here, I'll take it. Thank you, Your Honor.
Court does call the case, People versus Eric Casey.
Alexander, on behalf of the people, Your Honor.
Good morning, Rob J. Kill on behalf of Mr. Casey, who's approaching the bench. Eric, would you state your name?
Eric James Casey.
Judge, we have continuing possible settlement negotiations with Ms. Londe. I'm asking for an adjournment.
Adjourn the matter to September 3rd, 2025, 9 a.m.
Thank you.
The bond will continue. Thank you.
I want to say also, I want to thank you on, if you remember Tanya Hall, thank you for recalling the warrant.
I did that.
You did that. You're the kind and considerate judge I know.
And tell him you're welcome. Anyway, court calls the case. People versus Jennifer Gallara.
Allison, on behalf of the
Good morning, Marissa Boyles, P86438 on behalf of Miss Gallara. Will you state your name, please? Jennifer Gallara.
All right. As to the arraignment on this, you wait formal reading, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. What are you requesting? I need an additional pretrial date.
Yes, please, Your Honor.
Pretrial will be adjourned in this matter to September 3rd, 2025, 9 a.m. or as your invite indicates. Then as to bond alleged BAC in this matter.
a 0.187, and this is a first offense.
0.187.
Correct.
All right. Any accident?
No, you're right.
Set the defendant's bond at a personal recognizance $20,000 bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
There's also not to be any possession of any alcohol, recreational marijuana, or any illegal drug. Do you understand that? The level in this case, I am going to order that you report over to the Department of Community Corrections for placement on a SoberLink testing device. You're to do that within the next 24 hours. And probably would be your best bet to head over there right after this hearing.
Yes.
Okay. And I've signed that order. Anything else?
No, Your Honor.
All right. Thank you.
Thank you.
Court does call the case of the people versus Robert Stevens.
Mr. Stevens is or not, Mr. Michael Gaddy is attorney and private attorney. Mr. Lower Brown. So you can see any reason why.
So I don't know. What do you mean?
Mr. Gaddy is listed as the attorney of record.
I see that.
Mr. Lauren Brown indicated that there's no reason the PD should have to conflict out.
So it's a PD case.
But Mr. Gaddy is the attorney of record as now. The first time is. I'm sorry. I don't believe Mr. Gaddy.
Well, if he's appearing in his own personal capacity, I don't, the PD, that doesn't help me. Do you know where Mr. Gaddy is?
No, Your Honor. I think he might honestly be off this week, but don't quote me on that.
He may be off, but he's listed personally as the attorney of record. And not the PD's office.
Your Honor, that was my understanding.
I'll adjourn this matter September 3rd, 2025, 9 a.m. Court does call the cases of the people versus Rick Artuso, 3 cases.
On behalf of the people, Your Honor.
Public Defender Natalie Pate on behalf of Mr. Rick Artuso on the cases ending in 1656 and 1657.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as to the room.
Mr. Artuso, can you turn on your camera and unmute and state your name?
Rick Artuso.
Turn on your camera.
I'm trying to figure out how to do it.
Zoom started yesterday.
Yeah.
Anyway.
I'm trying to figure out how to do it. I gotta.
Your Honor, I can say that it's definitely his voice.
Yeah.
He's got it.
Yeah. Okay.
All right. So what are we doing?
Your Honor, there's a few pending matters, one's at circuit at this point, and we're trying to, and the prosecutor's office did mention some potential other charges, but they weren't sure that they were going to come in. So we're trying to globally resolve them, I guess, in a nutshell, Judge. So I was just going to suggest we adjourn the pretrial out so that we can resolve it most likely at the circuit court case with these cases following.
So I was going to respectfully request an adjournment as well, Your Honor. There is an offer to resolve both of these two misdemeanor cases that I did attempt to reach Mr. Artuso to discuss, but I do need to relay that offer to him. So I'd be correct requesting an adjournment.
Okay, and these other cases, when is the next circuit court pretrial date, do you know?
1 second, sorry. Believe it's this afternoon. I think it's this afternoon.
Oh, it's sometime soon.
It's this afternoon at 1:30, Judge. That's why I couldn't remember the
Got
date.
it.
Sorry, yeah.
Okay.
It's, well, it's Judge Hammoud, but yeah.
Hammoud will be hearing it, but the, okay, and then these other cases,
Mr. Emmons, I was told, Judge, that we're not sure about, you know, he was checking to see if they were gonna charge them or not, and I see.
There hasn't been any charges authorized on those, so I'm not sure who's currently reviewed or if they're being reviewed, so I can take a look at those this week.
All right. Adjourn this to September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
All right.
Your Honor.
Thank you. Thank you, Mr. Artuso.
Okay, thank you.
Court does call the case of People versus Nicholas Stemmel.
And good morning, Your Honor. Rita Young, P44626, appearing on behalf of Mr. Nicholas Stemmel, who is also on Zoom. Sir, could you state your name for the judge, please?
Nicholas Stemmel.
All right, very good. What are we doing?
Judge, we're asking for a final pretrial date, try to see if we can resolve this matter.
You don't want to do this Friday. I'm taking it. I should set it this Friday. We haven't seen you in forever, Miss Young. Make you come down here. But I'll give you the October dates.
You're so kind.
Jury final settlement conference will be October
17th.
October 17th, 2025, 9 a.m. Jury selection, if necessary, will be October 20th, 2025 at 8:30. Both of those proceedings are in person.
Okay, thank you so very much.
Thank you. All right, take care.
Likewise, Judge, can I hear who the prosecutor was? I didn't hear her name.
You know, she doesn't have a name. No, I'm kidding. The prosecutor actually assigned to it is Miss Landy.
Okay, thank you so very much, Judge.
Thank you.
All right, in our effort to continue with our commitment to bring 9 to 11% more Judge Boyd, let's go to Texas.
I'm so sorry. Oh, I wrote that on there. Never mind. All right, Adriana, there should be 3 files.
Yes, I think that the HIDA has printed out the other dockets for digital files and place it in that one file.
Ah, okay, thank you.
Yes. And Your Honor, I have copies of the motions if you need them.
Oh, no, I have your motions. All right, the court is calling 2022 CR 6907A, 2025 CR 006368, 2025 CR 007432, State versus Malik Lampkin. Can I have parties announced?
Dudley Pitlock for the state of Texas, Your Honor.
Hannah Hawkins for Mr. Lampkin.
All right, and are you Mr. Lampkin?
Yes, sir.
All right, so are you with the firm or?
Yes, Your Honor, I'm an associate with Alston Hagee's firm.
All right, do you have any objections to this attorney standing in for Mr. Hagee? All right, defense, you filed the motion, you may proceed.
Yes, Your Honor. We filed motions to reduce bond on the 2 new charges that Mr. Lampkin has, or 2 new cases, I should say. And then we also filed a motion to set bond on the other case, which he was being held.
All right, which case are you saying that bond needs to be set? Because all of the,
It's 2022 CR 6907A.
all right, so that one has no bond and that needs to be set. Is that the motion to revoke or no?
That's correct, Your Honor.
All right, so the motion to revoke, is that a deferred adjudication?
It is, Your Honor.
All right, so he's entitled to a bond on that case because it's deferred adjudication. And then you're asking for a reduction in cases that are alleged to have been committed after the motion to revoke.
That's correct.
All right, so first, let's take up the motion to set bond and 2022 CR 6907A. Were you all able to reach an agreement or no?
No, Your Honor, I don't believe that we have an agreement. I'm standing in for Mr. Hagee, and I believe that he spoke to the state yesterday. And they agreed to set the bond at 100,000. We are asking for 30,000, so we weren't able to come to an agreement.
All right, so you may present any evidence.
Yes, Your Honor, I'll call Ken Mouillet.
All right, Ken Mouillet.
Oh.
All right, can you raise your right hand?
Hello, Your Honor, how are you?
Hello. Right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Kenneth Moye.
All right, can you spell your last name for the court reporter, please?
Yes, Mouille.
All right, you may proceed.
Thank you, Your Honor. Mr. Mouillet, I'm going to ask you some questions relating to our motion to set bond for Malik, okay?
Yes.
So we're not going to be talking about any of the facts of the case. We're just going to be talking about his bond. Does that make sense?
Yes,
Okay. How are you related to Malik?
his grandfather.
How old is Malik?
Malik is going to be 22 in October.
Okay, so he's 21 currently. Okay. Is Malik financially independent?
No,
Okay. Does he have any money available that he can use towards his bond?
no, ma'am.
He does not. Okay. Are you trying to help him post the bond?
Yes, ma'am.
Okay. Do you know how long Malik has been in custody?
Yes, since March 18th.
March 18th of this year?
Yes,
Okay. And do you know, are you aware that he does not currently have a bond set in this case, the MTR?
yes, ma'am.
Okay. Do you know, Your Honor, is it okay if I ask him questions about the other cases, the other motions as well?
Sure.
Okay, okay. Are you aware of what his bonds are set at in the other cases?
Yes, ma'am.
And what are they?
It's 100,000 on one of them and 20,000 on another one.
Okay,
And there's no bond on the MTR.
correct.
All right, can we go off the record for a moment?
Yes, Your Honor.
Okay, we're in the Wayback Machine here a little bit, so I can nudge us past that. In the meantime, why don't you guys be the law nerds that stare at goats while I nudge this forward here a little bit for us. There we go, back to Judge.
Your Honor. So, Mr. Mouillet, you're aware that Malik was on deferred adjudication, community supervision at the time he was arrested for the two new cases.
Yes.
Okay. And what assurances can you give to the court that if Judge Boyd orders a bond that is an amount that you can afford, that Malik isn't going to get into any new trouble or pick up any new cases?
Well, number one, Malik is not in psychosis anymore. He was in psychosis on the day of the 17th. But number two, Malik is on medications from the University Hospital. The last 10, maybe 14 days, Malik has done excellent at the jail. He's always gone to his probation officer, and I've always fought him in front of you, Your Honor. When he needed to come, he'll be, residing with me. And his mother, we're going to be watching him, making sure he gets his prescriptions.
Mm-hmm.
And as long as he takes the medication, Malik is doing excellent. And that's assurances that we can give the court, but he has to be on the medications, Your Honor, and the psychiatrist at the University Hospital has done an excellent job. And as long as he doesn't go into psychosis, I think the community is safe with us and everything.
And where would he reside if he was released on bond?
In my residence.
Okay. And are you working full time?
No,
So you would be able to supervise him?
yes. And I even have him a job lined up, Your Honor,
Where would that be?
at Wendy's. Through his, one of my nephews.
Now, one possibility is that the court could order him to be on the GPS monitor. You understand that possibility?
Yes,
And are you aware that that would effectively restrict where he can go?
yes,
And is that something that you are amenable to and would
Oh.
understand if the court ordered?
yes.
And you would ensure continued compliance with his medication?
Yes. And also we take him, he has patient support with Miss Abrams, you know, his probation people.
Sure.
He's always done everything, yes. So we make sure.
Let me ask you this, how much could you afford to pay for a bond right now?
mm, the bond, the amount. that
How
the
much
judge-
money, do you have that you could put towards a bond?
We put $2,000.
Okay.
Okay, I'll pass the witness, Your Honor.
All right, any questions?
Briefly, Your Honor. Did you know that we had already tried? Oh, I can speak louder.
Yes.
I'm sorry.
Louder?
Yeah, because I'm ex-military like you're.
Yes, no problem.
Yeah.
And I understand that it's one area is he can hear better on this
And
side.
thank you for your service, Your Honor.
No, I haven't served.
Oh, you weren't in the Army?
No, I was not.
Oh, you were just thanking me and I thought.
Yes, yeah, no.
I said, oh, thank you for your.
Oh, no,
That's my hair. That's my hair.
Appreciate it though, but I don't want to accept what, isn't due. So no, I haven't served.
And I was gonna say, thank you for your service.
Oh,
Oh, okay, sorry.
no problem.
Were you aware that we had tried GPS already?
Oh, yes, and the judge even allowed, Malik to, oh, sorry.
No worries.
I'm glad you went down there because I wouldn't be able to get back.
No.
Yeah, and the judge even allowed Malik to go to Disney World for 9 days and to go down to the coast to be baptized last year.
And that was all while on GPS?
No,
That was after the GPS was removed?
yes, sir, and that's when he wasn't in psychosis.
No. Do you know your grandson to smoke marijuana?
He has what's that called, a medical,
Medicinal?
yeah, where the doctor gave him a medical prescription.
Is this the same doctor that gives medication that would help with the psychosis?
No,
Different doctor.
yeah, we had to go to the university psychiatrist.
Does the doctor that prescribed the medication for the psychosis know about the marijuana usage?
Yes,
And everyone thinks that it's okay and that it's not, there's no substance issue, it's not counteracting things like this.
well, no, because they said Malik has been diagnosed with 7 diagnoses. From schizophrenia all the way to bipolar schizophrenia, anxiety, depression. He has 7 diagnoses, so they're trying to keep him calm where he can even do a part-time work. So we lined him up a part-time, maybe 3 hours at first at the Wendy's, only because it's family.
Yes. You are aware that the offenses that have been alleged are violent, some are violent offenses.
Yes, but they were committed when he was totally under psychosis.
Do you feel safe with him?
Oh, yes.
No further questions, Your Honor. Thank you.
All right. Thank you so much for coming in, sir. And
Oh.
thank you for doing what you can to help him.
Oh, okay.
All right, thank you. Any other witnesses?
Other witnesses, Your Honor.
Any witnesses state?
None from the state, Your Honor.
All right. So, Mr. Lampkin, this is where we are. On deferred adjudications, you are entitled to a bond. Although there's some case law that says if you are alleged to have committed new offenses that are violent offenses, you may not be entitled to a bond. But the law is still open to interpretation on that point. What I can tell you is the state is requesting $100,000 bond. Your attorney is requesting $30,000. I don't see that $100,000 bond is outside the realm. And let me just tell you why. I understand your mental health issues because from the last time I saw you, and when I say the last time, I don't mean just yesterday by Zoom. I mean, much prior to that, I could tell that you had been off your medications because the person who's before me now wasn't the person who was before me who wasn't on their meds. But I want you to understand something. You're on bond, well, you're on deferred adjudication for robbery. Robbery is sort of right here on the level of felony cases. Then you're alleged, and I don't take it as true because it's just an allegation. Then you're alleged to have picked up an aggravated robbery, and an aggravated robbery is about right here because it's above the robbery. And in that same day, you have a theft of person, and a theft of person is down here below the robbery. So part of my job as a judge when considering the amount of bonds to set is protecting the community. And I know your grandfather has testified, I'm not going to be able to make $100,000 bond. That's too much compared to all the other two cases that you have. And I balance that with protecting the community. So I'm going to set your bond. In this case, I am going to set it at the 100,000. And I'm going to order GPS tracking, and I'm going to ask that the fees are waived.
Thank you.
And then I'm hopeful that both the state and your council will see what can be addressed with regards to the mental health issues. I don't know if there are going to be motions that will be filed to suggest that maybe you were insane at the time of the offense. I don't know. So I'm just here to have the bonds to address the bond issues. And in cause number 2025 CR 00636, the request for the reduction of bond is denied. And in cause number 2025 CR 007432, the request for bond is denied. All right, we can go off the record. So counsel, in this case, if you all, I don't know if you're going to file motions, but if you're going to file motions, I don't know if he's able to afford a psychiatrist to address any mental health issues at the time of the offense. But if that's something that his family is not able to pay, then you'll come back and I'll hear any evidence with regards to that and whether or not a psychiatrist should be appointed.
Thank you.
All right, thank you. Is there anything else? Would you like to get a reset? I think we're set for discovery on September 22nd. But if your attorney wants you brought back sooner than that, they'll let us know and we help you brought back sooner. All right, so here's the thing. I can't order you to take your medications at the jail. But what I can tell you is your presentation to me is better than what I saw it, months ago, okay? All right, good luck to you.
Thank you.
You're welcome.
So in the chat, you're all saying how much you like how she's breaking things down and giving her reasoning and stuff like that. And I would tend to agree with you. I'm not going to get off on a full rant here, but just to say, the more I get into this, the more I do struggle, though, with the whole concept of bond amounts, because she says that she's setting a higher bond amount to quote-unquote protect the community. But it's not like if he made that bond, the community would be more protected than if he made a smaller bond. I wish we could just cut to the chase and say, I don't want you out. But unfortunately, the laws are written so that we have this almost feel-good backdoor way of keeping people in jail by setting a number that they're not going to be able to reach. I wish things were simpler. I wish we were more plain with things, and I wish she just had the ability to say, I don't think you should be out, so you're going to stay in jail, rather than saying, well, this high amount will protect the community. Because again, if he made it, it's not like the community would be any more protected than if he made a smaller number. Just my thoughts on that. Feel free to debate it in the chat. Let's stay in Texas, but go back to Judge Stevens.
2 state jail felonies. She's pleading to second-degree burglary without patient.
Okay. Yes, I need those to be. Again, thank you.
All right, let's pull it up.
I'll bring mine. How's that sound? You call 24 CR 1317, huh? And 1318 and 1319. And the state of Texas versus Clara and Equivoto. That is you, present. Mr. Adams, you're returning to the state's attorney. In 1317, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in a summary fashion?
Yes, sir.
In summary, this indictment alleges that on or about April 14th, 2024 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you are charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable for this offense?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended, and then you would be placed on regular probation, which can be up to 10 years in length. A fine will be assessed of $500, plus you must pay restitution in the amount of $1,338.16, which I presume will go to the complainant in this case. That's great. The owner, Karen Roland, who's mentioned in this indictment. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal. Do you understand? How do you plead to this charge? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document up at the top?
Yes, sir.
Did you understand it? Discuss it with your attorney, Mr. Adams, everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it is admitted. Among other things, thank you so much. The state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. You read it.
Yes, sir.
You guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. Totally satisfied with the representation provided by the lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1. No part of the all purposes. Pre-sentence report is waived.
Yes, sir.
Then I will so find you are pleading guilty, voluntarily, knowingly, intelligently. There is sufficient evidence supporting your guilty plea. Your State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You are giving up your rights to the trial, your rights to the appearance, confrontation, and cross-examination of witnesses. You are totally satisfied with your representation, and I am going to follow this agreement. You were hereby found guilty beyond a reasonable doubt of this second-degree felony of burglary of a habitation. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You will be placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500, but even more importantly, there is restitution, which will be owed in the amount of $1,338.16, which needs to be paid back to the complainant in this case. How long will it take you to get that money back?
maybe a couple months.
I'm gonna give you 3 months, okay? Almost took it as a souvenir. 90 days, okay? And that will be part of the probation order. Restitution to be paid within 90 days. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Fix this and move on with your life. Do better. Okay. What were you gonna say? What were you gonna say?
See, Tom, I don't know who I owe money to though.
They're gonna tell you. It's in the name is in the indictment, and the probation office will work you through all of that. Okay? Yes, ma'am. Anything else? That is all.
Thank you, Jeff.
Yes, sir. And okay, 2 other cases, 1318 and 1319 on Kara Quibido for being dismissed at this time. As part of this agreement.
You're done here.
Who do you have? Corey, your patient?
I have Mr. Hanley, Judge.
Already
Sent the paperwork to the state. If you could just give them that to us.
He needs to come in front of her.
Here.
Is it both?
Dismissal. He had my thoughts. So a lesser included.
All right, well, they're between contestants. Let's go back up to Judge Simpson, where a young Ronald Reagan appears on behalf of Pittsfield Township.
Herself. Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a LaTasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you.
I served 30 days already.
And if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. If I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you gotta make a decision, man.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or not?
It doesn't matter.
You have to make a decision, man.
It could have a jury, fine, that's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by parenting. The whole
That's-
McDonald's thing and then this. And...
This-
Okay, let's try this one. Court calls the case People versus Deja McCoy. Is she here? Oh,
Brandon Center, Your Honor. Actually, she was there when I was walking out, Your Honor.
how come you didn't come back? You guys got to switch sides.
Sorry about
How come you didn't come back?
I came back, but you was gone. I figured you
I have
left the
been
bench.
here.
I
Don't
figured,
say
I'm
I-
talking about, I
no,
figured you left the
no.
bench. I
Why
figured
didn't you
left
come
the
back?
bench.
The client was here.
When I was
And the
going
things
out.
he was saying about you, I was defending you. I want you to.
I was saying dismiss.
He was, I think, making. Okay. Reality is, I think you were making your decision because you wanted McDonald's, and you kept saying she wasn't here. That's why you didn't come back down the hallway, isn't that right, Bert?
No, that's. No, I'm talking about when I was walking outside. We crossed each other's path.
Outside, you weren't going to turn around.
Oh no, I wouldn't have did nothing like that.
You had McDonald's on your mind.
I would have got Coney. I had Coney on my mind for real. But I had to stay there. Didn't have time for it. But yes, Your Honor, Brandon Bird on behalf of Deasia Yargi McCoy. Ms. McCoy, can you please state your full name for the record?
Deasia Nicole McCoy Yargi.
Thank you, man. All right, what are we doing?
Respectfully, Your Honor, we just asked for adjournment to give me some time to talk about the offer with my client and to go over these videos with her.
Okay. September 3rd. Is there enough time, sir?
Actually, I'm started trial on September 2nd, Your Honor, and I'm not sure if it'll be done on the 3rd.
Yeah, you look at it like you. September 17th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Have a
You
good
and
day.
Your Honor McCoy have a good day.
Okay. Did you get your food?
I did.
Okay, all right. Court does call the cases of the People versus Jay Dingman.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Dingman. Mr. Dingman, please state your name for the record.
Jay Ho An Dingman.
Thank you.
Your Honor, unfortunately, I did not have a chance to speak with Mr. Dingman. I was calling him, but however, he's in custody.
Yes.
Obviously. I believe he's being held on a felony case. That is before Your Honor. I do not remember the next date. I would ask for the next possible date so I can have a full conversation with Mr. Dingman about what's going on these cases and how we can resolve them.
He's up tomorrow. Okay. And what I'll do is I'll adjourn all these to September 3rd, my next day, 2025, 9 a.m.
Thank you.
I'll see him tomorrow.
And I apologize, Mr. Dingman, for not speaking with you.
Thank you. Thank you, sir. Court calls case People versus Renee Darga.
Alexander, on behalf of the people, Your Honor. Your Honor,
I'll issue an order to show cause for defendant's failure to appear. Calls case People versus Alonzo Doss.
Alexander, on behalf of the people, Your Honor.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Doss, who should be present via Zoom.
Hello,
Mr. Doss. All right. Do you have a camera?
Yep, trying to cut it on. Yes, sir. Sorry about that.
Oh, there he is. Okay. What are we doing?
Thank you, Your Honor. Your Honor should be in receipt of a plea form and police report. There is a resolution in this case to which my client would be pleading no contest to an added count 2 of retail fraud in the 3rd degree, and in exchange count 1 of retail fraud in the 2nd degree would be dismissed.
Okay, that's the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor.
All right. Sir, please raise your right hand. You need to be someplace stationary.
Okay.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Alonzo Doss.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud 3rd degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about it. I have to make sure that you understand. The first thing you need to understand is it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for no contest plea.
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud 3rd degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
Under paragraph 5, those are your rights that are part of a trial. You understand you're giving up those rights as well as all the rights that are contained on that form.
Correct. Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Correct. Yes.
Your own free will?
Yes.
Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-19959. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, or not counsel, but sir, I need you to understand that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea. And you would also, the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Can you elaborate a little bit on that, Your Honor?
All right, under the Michigan court rules, there are certain things that are misconduct. Say, for example, violation of your bond conditions, right?
Okay.
If you do that between now or between the time that I accept the plea and your time of sentencing, if there's some type of misconduct committed by you, commission of another offense, those kinds of things, then what would end up happening, sir, is that the court would no longer be bound by any sentence evaluation. There really isn't one in this case, but also you would not be entitled to withdraw your plea.
Okay, so I'm sure other than breaking the regular laws and something along these lines that got me here, outside of that, is there anything else?
Mr. Doss, it's pretty much if you continue your compliance on bond and you don't commit any alleged offenses, that should not come into play. But in this case, you don't have a sentence agreement anyway.
Okay, like basically what I'm getting to, if y'all don't understand, is like when you're on probation or parole, you have certain stipulations that you can't, or on bond. I was trying to make sure that there wasn't any specific, like other than me not stepping foot in that location, is there anything else that I should be aware of?
Nothing new or additional since we last spoke, Mr. Doss.
Okay.
Okay, do you understand what I just told you?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor. Not that I'm aware of, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2, the retail fraud 3rd degree. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27th, 2025, 12 noon. All right, sir, you need to hang on the line. I have probation intake on the screen. We're going to put you into a breakout room so we can get the process started, okay?
Yes, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Mr. Doss.
Court does call the case. People versus Gibson. Stephon Gibson.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Gibson, who is approaching. Please state your name for the record, sir.
Devin Gibson.
I have before me a plea form that indicates that the defendant would be pleading no contest to the charge of assault and or assault and battery. The 93-day offense. Upon the successful plea to that charge, count 1 would be dismissed. That's the court's understanding of it.
That's correct, Your Honor. That is correct, Your Honor.
All right. May I have him sworn, please?
Yeah. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so we got.
Yes.
Lower your hand and please spell your name.
Devin Gibson, DEVON GIBSON.
All right. Mr. Gibson, this is court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
Basis for no contest plea?
Potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
No contest.
You understand? That's all right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form. Is that correct?
Yes, sir.
Any question about any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes, sir. And of your own free will? Mm-hmm. Yes? Yes, sir. All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 2529070. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, are you, sir, I do have to advise you that if you commit misconduct between today's date and the time of your sentencing, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and you would also not receive the benefit of any sentence. The court would not be bound by any sentence recommendation or evaluation. You understand that, sir? Yes. All right. Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27th, 2025, 12 noon. All right. Probation will be down to see you and try to get everything all set. All right, sir. Okay, thank you.
Thank you, Your Honor.
Bond continue.
All right, I need a bit of a break from staring at Reagan there, not because it's a Reagan lookalike. It's just kind of creeping me out a little bit because Reagan's been gone for a long time, and this guy is just like the spitting image of a young Reagan. Let's go back to Louisiana, see what kind of craziness they've got for this guy.
Stapleton, we're the Committee on Parole. We'll be deciding about your revocation this morning. I understand that you're in you're in Claiborne Detention Center. Is that correct?
Yes, sir.
Okay. And
Yes.
is there any staff in Claiborne there?
Yes, yes, sir.
Would you, staff, would you introduce yourselves, please?
Hi, I'm Carmen Nixon. I'm the transition specialist here.
Okay, Ms. Nixon, thank you. Thank you. I appreciate that. And appreciate you hosting us this morning. Mr. Bocher, what's your DOC number?
513603.
513063 sound right. Yes, sir. You passed that test. Okay, good.
Yes,
Well, we're gonna give you a chance this morning to talk to us about your revocation here. This is our second hearing of the day, so we've already introduced the staff here and all that. It's 8:58 in the morning, just for purposes of the record, August the 6th of 2025. Your case has been assigned to Miss Carolyn Stapleton, to my left, and she's going to be handling the entire proceedings. But we have well, let's see, I'll go ahead and turn it over to Ms. Stapleton. And Ms. Stapleton, at the appropriate time, if you call on
Okay.
the witness.
Okay, sir, let me pull up the case here. Do you have a questionnaire in front of you? Do you have a questionnaire in front of you that you signed?
Yes, ma'am.
Okay, all right, so we can proceed. All right, so we have in front of us that you violated condition 4, 8, and 10. And so I'm going to read each one out to you, okay?
Yes, ma'am.
Okay. Number 4, I will not engage in criminal activity, nor will I associate with people who are known to be involved in criminal activity. I will avoid bars and casino. I will refrain from illegal use of drugs. It said you committed the offense of battery of a dating for third offense on or about 10/20/2024 On 5/23/2025, you pled guilty to an amended plea of simple battery and was sentenced to 4 months in the parish jail with credit for time served. What you plead to that one?
Ma'am, the reason why it was, if I may speak, it was because of the district attorney, James Clark. And I didn't want to take the plea of that charge, but he because I was, first of all, I never committed the charge, the crime. I don't want to fight it, but he was stating that they had wrote a affidavit saying that it wasn't me, but he still didn't want to amend the charge to dismiss it. So he like, I guarantee you that they will not violate you if you take this charge. I'm like, but man, they're gonna violate me because it's a crime of nature. He like, well, no, I've been doing this. This is what I'm specialized in. So if you take this plea, then I'm guarantee you that you're gonna go home. I got kids out there. I do have a past history. As enough as much as y'all can pretty see.
That's violence, right? Because this is third offense.
Yes, ma'am. So that's why I didn't want to take, because I never committed domestic violence on this time.
We're going to cut to the chase. This is where they got probable cause, okay? The police were called out on October the 20th, 2024, and they responded to reference to a battery of dating partner. The victim was Althea Callis, and the suspect, Corey Bozier. You'd been texting her to come over to the residence, and she denied your request. She came over anyway. And Mr. Bozier turned to Ms. Callis and struck her in the face, causing her mouth to bleed and for her to have a cut on her lip. And you did that with a closed fist. So in the report, I'm not going to read the whole report. The injury sustained was swelling around the lips, bleeding from and within Ms. Callis's mouth. So I
had a witness. I have a witness, some witnesses to where when that allegedly happened, that's why I wanted to go to trial. I had witnesses when this allegedly happened where I wasn't even there. I couldn't be at two places at one time. I had my significant other should have been on
lawyer's advice and you pled, okay? And it was pled down to a simple battery.
And then yes, ma'am. And so they told me to take if I take the plea, I wouldn't be in front of y'all this morning.
Well,
that's
okay, so let's move on, okay? So you're pleading not guilty, even though you pled guilty to that.
Yes, ma'am. I'm not guilty.
Okay.
Yeah, it's my significant other as well on the hearing. Excuse me. Because she had tried to log in as one of my witnesses. And
okay, all right, so Miss Christy Harris.
Yes,
is she's on.
Because she had called and said they was going to contact her back when the hearing started. Because I was with her, and I can't be in two places at one time.
Not able to get through to us. The number that we have is the wrong number. The number that we have here is the wrong number.
It's 337-442.
Okay. Hold on just 1 minute. We had the wrong number. They're going to try that number. Okay. All right. So let's go on to number 8. It said you did not successfully complete the Lafayette Parish Sheriff's Office day reporting program.
That is correct. Due to me having the warrant out for my arrest behind this charge, behind the charge, I couldn't complete it. While I was in it, I was active. I had one dirty UA when I first got there. I did have test one positive. From testing that positive, I stayed in there, I want to say 12 weeks after, and I was clean. All my UAs came back clean. I was negative, as well as being active in being like a group leader as a mentor, as well as participating wise into the group. And that was at Lafayette Parish daily reporting.
Okay, well, it says here that Bossier admitted to this violation. Okay, so I guess you were hiding because you had a warrant out for your arrest, right? So you didn't complete here.
No, ma'am, I had that.
Okay, so would you like to go ahead, Ms. Harrison, speak?
Hello?
Yes, ma'am. Would you like to speak?
Yes.
Okay, what do you have to say?
He like complied for everything and like the girl that really did for the charges is false charges because like the day that she did that it was done, he was with respect. I'm gonna be honest with you, like he was living with me and my mom, like my mom, my brother, and my stuff there. They about to like with the internet, and then she found out that it was dating. That's when she went about the false thing. So yeah, if it's any way possible that like y'all could grant him, parole or whatever. Because like I said, he was doing what he was supposed to get going for his classes. Like passing all his drugs, and then, looking for jobs or whatever. Like, he really was trying. Like, and then she found out that he was dating. He made some all his boys report.
Okay, well, we have a police report, and in the police report, the officer actually gives a description of the injuries. And he pled guilty to simple battery on that one. And then he also pled guilty to not reporting to the day program. So, thank you. Don't hang up. Oh, okay. All right, we'll wait until she hears it.
And the reason why when I did the hearing with the parole officers, with the classes, like I told them that it was due to me, I couldn't be into the program with the warrant on me. So I was trying to get the warrant resolved, and the only way I could get the warrant resolved is to come and to turn myself in, be placed in custody. That was the only way I could have. So the program now, as far as completing it, no, I did not complete the program, but it was only due to the fact of the nature of I had a warrant. That was the reason why.
All right, and then number 10, you are $1,134 in arrears of your supervision fee and $65 in arrear for your processing fee. Earlier you admitted you are guilty to that. What do you say to that?
Well, I know the same thing. I spoke to my parole officer, and he had given me a waiver of allowing me to have time to work with the get the fees because I was incarcerated. And this is like
grade arrears, but he was working with his officers to get them caught up. So I see where that is. So my next. Okay, so the one that we've got guilty for that you admitted guilty to was number 8, correct?
With the program?
Yes, with the program. And then you had a guilty plea for simple battery.
And like I said, the only reason why the plea of that simple battery is because of what the DA and like I got my kids. I was just trying to get home to take care of the kids. If I knew that's what it brought me in front of the board, then I would have just continued to wait it out because I don't want to plead guilty to something that I ain't guilty to, with all due respect. And when he was guaranteeing me, and he like, trust me, I guarantee you, you will not be violated of your parole. And I'm like, man, I can't do that, man. He like, man, just trust me, man. And my lawyer advised me as well.
Mr. Bode, Ms. Bowden, I've got a police report, and you're a third offender for
And she has the
domestic violence
affidavit.
based upon probable cause.
Do
And
you
this
have the affidavit as well? She wrote of admitting to her, she had wrote an affidavit admitting that she was on medication and had a surgery.
Okay, listen, we're gonna cut this off. Based upon probable cause that existed for number 4 and number 8, and I know your parole officer was working with you on number 10, I'm gonna revoke you today.
This, you have any questions, Ms. Bevan? Excuse me.
Yeah.
Would do.
Are you a 5th felony offender?
Yes, ma'am.
I just didn't know if it was 3rd or 5th. Okay, that's all.
Yeah, because I mean, like, my understanding is I'm getting revoked today, so I was really swindled and taking a plea.
Okay.
I was
I
swindled
had
by
a
the
question
DA.
about what your offender class was. That I'm not, because she
No,
said
yeah,
3rd,
yes, ma'am.
3rd violence. Okay, thank you.
Yeah.
That's all. My vote is to revoke today.
And I had a question. No, I had a question though.
Evidence.
Yes, sir. Yes, sir. There'll be a time for questions and all that with the board later, not this morning, because this is your hearing. And I think that it takes 2 votes to revoke you. You already have the 2 votes. And my vote also is to revoke. And so as of 9:12 this morning, your parole has been revoked. Thank you, sir.
Denied.
I will say that one makes a little more sense than the last one to me, so I'll grant them that. Let's go over to Judge Stevens. I need to step out of the studio for just a couple of minutes. Michael, you're in charge. I'll be back.
Hello. I'm okay. How do you explain that to the nut? Good luck. I got hit with a stylus right between the eyes.
But can I have those files that just flood?
Yeah. Thanks.
Thank you.
I know it's progress, but it is the writing. You can't write.
Oh, it's horrible.
Clean.
My penmanship is already rough. I've had that.
We're getting new ones October 1st,
Oh, great.
the new budget.
I thought these were. I thought these were.
That's not a day before.
Okay, next.
This is Mr. Hamlin.
Mr. Hannon.
He has 2 cases, Judge. He has a theft that's being dismissed in exchange for restitution in full, and another state jail felony that's we're proceeding on the lesser of attempted.
Now, do I have that, or do you have hands?
Yep, you get that.
Which one? To be pleaded?
We were pleading on the prostitution case, Judge.
229. Okay, 25 CR 229 and 23 CR 1459 are both all the state of Texas versus Jerry Stephen Hadley, which is you, sir. And you were present with Mr. Crenshaw, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here in 229? Can we proceed in summary?
We can, Your Honor.
In summary, the indictment alleges that on or about November 21st, 2024 in Jefferson County, Texas, you committed the state jail felony of solicitation of prostitution. I'm looking at the plea agreement here, and it's been written all over that he would be pleading guilty to the lesser Class A misdemeanor of attempted solicitation of prostitution, which carries with it up to 1 year in the county jail and or a fine up to $4,000.
Judge, there's restitution from the other case that's included in to give him 30 days to pay as part of this plea bargain agreement to dismiss the other charge.
It's a large amount, Judge, but he's got the money. We just need to move it to the right account. It'll be paid.
Okay, is it going through this case?
Yes.
Yes, sir.
It's gonna go through this case.
Yes, sir.
So what is that?
30,371.03.
All right, then.
It's in the, I think it's in the plea agreement on the punishment part.
Okay, let me ask you, you brought on this one, 1 year and or what's that?
$4,000 fine.
That's 4,000?
That's four. Yeah, that's a 4. That's 3 zeros, and that's we're fine.
In what language? I was just.
Swahili.
Sanskrit?
Times New Roman.
Okay, what I need to do is, use. Put the dollar sign, so. I'm gonna do. There's two. We're just gonna wait to do it.
Did you put a fine on this?
I did not.
Okay, that's what I thought. Yeah.
Since we're paying the 30,000.
Yeah, there's another case. I gave you that. Oh, yeah. Couldn't open a stopper and take for that or something. No. That's
Oh, to 4,000.
That's what that was. Just making sure. No.
Yeah, just. Right.
Making it worse.
I said it's church. Okay. How do you do that? I would do the finger phone. No, yeah, it's some judges of you now. I don't know why. We're all struggling.
Yeah, it's okay.
We give me tablet October.
So again, you're looking at up to 1 year in the county jail. And, or a fine, or up to, $4,000 fine. Do you understand?
Yes.
We don't have jail in there. It's up to 1 year. And we all know it's jail.
Okay.
She said, just have to see go. You understand what you're going to be pleading to, the lesser included offense and the punishment range that's related to it, sir. The agreement's been reached where you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length. And got some. There's no fine. And another case, 26 CR 1459 will be dismissed as part of this agreement. And you will also be ordered to pay restitution in the amount of 30,000.
371.
$30,371.03. That will go to whom?
Oh, go. What was your previous employer? Siddons Martin, Judge. SIDDONS Martin, Standards Appellate.
Is this part of the 1459 case?
Yes.
Okay, there is an owner there, McLeod. Is that the person?
No.
No.
I think that was his boss.
That was the boss. Oh, there's a company that owns.
Yes, that was his former employer.
Okay. What's the company's name?
Siddons Martin.
Okay, so restitution will go to Siddons Martin. And that's a company.
Yes.
how do they spell it? Siddons, Martin? Okay, where are they located?
Port Arthur.
In Port Arthur, Texas?
Houston's
corporate office, okay.
But you were at their Port Arthur office.
Okay. If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will
Yes, sir.
and because you are guilty.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. And you hadn't signed this. The bottom. Here, use this pen's a lot better. The stylus works better.
So right there.
I know you reviewed that document. It was discussed by Mr. Kenshaw. That's the way he does things. He takes care of his business. And have you discussed this with him? And is everything true and correct here on State's Exhibit 1?
Yes, sir.
State's Exhibit 1 is admitted into evidence without objection. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help me God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement and find that you are indeed mentally competent, sir, to enter this guilty plea. It's freely and voluntarily made. You know and appreciate the consequences of entering into this agreement. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to do this. So long as you follow the terms and conditions of probation, I will not find you guilty. You will be on what we call deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation which are normal and customary for this type of offense. Most importantly here, restitution is agreed by all parties to be owed in the amount of $30,391.
71.
That's a 7? Okay. $30,371 and
3 cents. 3 cents.
that's it. Okay. Well, no,
Yes, sir.
Nobody's at fault with this thing. You can't. This doesn't look like a 3 and it doesn't look like a 7. And but you understand. I'm reading into the record, and we're going to have to fix this on this pad. That will be owed. How long is it going to? How will you make these payments here? Probation for 2 years.
He's going to be paid in a couple of weeks, Judge. He's
Oh,
already withdrawn the money out of his retirement. We're just got to
Okay.
move it between
Okay.
accounts.
In a couple of weeks.
Yes, sir.
So what I'm going to do is order this to be paid within 4 weeks. Is that going to be enough time?
The agreement said 30 days, Judge.
30 days. 30 days. That's a little more in 1 month. 30 days. Okay. As a condition of this agreement. Please see the probation officer.
Yeah. Order shot.
No, did I sign it?
No, I don't.
The other one's to search them.
And there's a dismissal, I think, coming, right?
Under civil law, it is.
Huh?
Under civil law. it is.
Please see the probation officer. Thank you.
Thank you, Judge.
Yes, sir.
Have a good day.
And you too. Thank you.
Yeah.
Okay, and we have a dismissal forthcoming, right? On 1459. On Mr. Hammond. Let me know when that.
I don't have the dismissal just yet, Judge.
Keisha Bernard. We ready on that? Who's your attorney?
Okay, guys, I see in the chat where you're talking about what's happening in the on the military base in Georgia, where there's an active shooter situation. Bear with me just a second, because I'm gonna grab something here. Oh, that's interesting. Unrelated, I need to look, but it looks like Judge Boyd pulled her video from this morning, which she never does. So I need to see what's up with that, because that's really weird. Alright, give me just a minute here. Alright, I believe this is the 911 call.
We want to play that 911 call that we got earlier for you all, so you all can hear kind of the chaos that was happening at Fort Stewart as all of this unfolded at around 11 this morning. Take a listen.
Mag Station 1, mutual aid request for a gunshot wound on Fort Stewart. It'll be building 8420 2nd Brigade, 8420 2nd Brigade, gunshot wound, mutual aid.
At WJCL 22 News, we were actually in our newsroom when we heard our police scanner actually report this incident. We immediately heard active shooter at Fort Stewart, started making calls immediately to see what we could learn. At first, we were told that it was just a lockdown. They were working to get more information on what exactly was happening. And then I would say it was about 10 to 20 minutes later that we did get it confirmed that there was an active shooter, or possibly still is. And then it was probably about 10 minutes after that, so maybe at around 11:30, 11:40 in the morning, that we got confirmation that there are casualties reported as a result of this incident. Again, we're still working to learn whether the threat has been contained, whether there is still an active shooter. I think that's the big question on a lot of people's minds. But again, the fort is still on lockdown at this time, so
I'll keep an eye on it. I don't think that was an actual 911 call. I think that was a call over police frequencies. But either way, that's apparently what came out. So I'll keep an eye. Let's go back to Judge Stevens.
Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You might be read you read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for that purpose. Pre-sentence report, Wiley?
Yes, Your Honor.
I'm going to follow this agreement then. I'm going to find that you, sir, are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by a previous convicted felon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Justice to serve a term of 10 years. That will be suspended. You were placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation that the probation officer will go over with you here in a few minutes. Make sure you follow this. If you fail, your probation could be revoked. Well, he's definitely afraid of me filling out anything. Did you notice?
Yes, well, I heard something about that, but I didn't want to.
That's the word on the street anyway. I think I saw that on the news.
I didn't see that.
Don't let him sign anything.
Never watched the news. I don't even have local TV stations. It's between. Calmer.
All right, one other thing. Your second felony conviction. You know what it means next time? 25 to life. You're fixing all this, right? You're changing. We're going on the right path. Right, make better choices.
Completely honest with you, he has a very good career and
a lot to learn. You've got a lot to live.
It's just the weapon situation.
You got to be careful.
Cash business.
I know, but you got this, it's like a minefield you gotta deal with. But when you have that prior conviction, you gotta be careful where you walk. You don't wanna step on a mine. And this next one's a really big explosion. You know, a third one. So you don't want that. Okay, but it's fixable. Please see the probation officer. Thank you. Thank you. Yes, sir. Ryan, y'all had something?
Yes, that's from,
Who is it?
Luke Cooper.
Luke Cooper.
Please deal.
Come on.
I know that's so rare for me to please something. Throwing you off for a little bit.
I'll notate it on the calendar. You get a gold star.
Mike was being reasonable. It was a reasonable Wednesday.
24 CR 1888 is now called. Luke Anthony Cooper. Thank you, Mr. Cooper. And you were here with your attorney, Mr. Gertz, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment can be proceeded in summary?
He will, Judge, we can.
In summary, this indictment alleges that on or about April 30th, 2024, in Jefferson County, Texas, you committed a third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with here? Yes,
Yes, sir.
Okay.
Yeah, I think everything there, so you got the so.
Okay, we have a lesser included evading arrest, right? Which is a class A misdemeanor.
Yes, sir.
But y'all have, no, it's this.
The tablet, that's just some delay. It's.
Oh, it's.
But I thoroughly.
I want to spoil that was. Just make sure you do it right.
Different range in this.
Oh,
Can't read by right.
we've never had that occur before, have we? No.
I don't have that at all before. Are you man? Talk about me.
No, it's Jane. It's not James.
He's a lefty stuff in the house. Move it.
No,
It's still stick like.
there's no problem.
I think it's the pressure. Oh, okay, it's a pressure.
Okay, class A misdemeanor carries with it, if convicted, up to 1 year in the county jail and or a fine up to $4,000. Do you understand?
I understand, sir. Yeah. Okay. There, we can try to good. Yeah, it's the order of the trial. And we're gonna get.
Let me do this. I'm gonna work on this thing.
Yeah, Helen, Ryan, I wonder if you wore like a glove,
See,
like a glove
see.
over him, so when you do it. It's,
This drives me crazy. I'm not believing it. I don't know why. You can go as fast. Yeah.
Looks like this. Every time you set your phone on, it's design since it's just some of the free.
I got to figure out how to massage that. But I'll figure, Bruce will figure that out.
Okay. Yeah. An agreement's been reached where you would be placed on deferred or unadjudicated probation for 2 years. There's no fine. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
That's wrong. What you're saying.
If I follow this agreement, you have no right of appeal. Do you understand?
I understand, Your Honor.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of this offense and any lesser included offense? I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime and any lesser included offenses like this one that you are actually pleading guilty to. You are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is hereby read.
Yes, Judge.
I am going to follow this agreement, sir, and find you are pleading guilty to this lesser included evading arrest or detention, a Class A misdemeanor. You are doing this voluntarily, knowingly, intelligently, mentally competent to do so. You understand and appreciate the consequences of pleading guilty, even though there's sufficient evidence to support a finding of guilt beyond a reasonable doubt. The court is going to defer any finding of guilt. Place you on deferred or unadjudicated probation for 2 years. Make the most of this. There will be terms and conditions of probation, which are normal and customary for this type of offense. And I think defensive driving is going to be one of those, which is really a win for you because your insurance will be decreased. The cost of your insurance will be decreased by taking this as a requirement of probation. So
It's a benefit.
yeah, you can't say that you're being stung on that one. You're getting a benefit here, but you understand the seriousness of this. I don't have to tell you. We have far too many terrible things that have happened with people fleeing the police, and then a crash happens, and then we've had weeping and crying fatalities, and everybody's sorry. But you can't, you know, it's a mistake. Welcome to the world. You made a mistake. We all do. Everybody in this room has made them. Fix it. Okay. And that's the test of character.
Okay, we get all of that, but so this thing that we're monitoring, they have the shooter in custody, and a statement has been put out. 5 soldiers were shot today in the active shooter situation in the 2nd Armored Brigade Combat Team area. Soldiers were treated on site and moved to the Wynn Army Community Hospital for further treatment. There is no active threat to the community. So whatever happened there has happened. They've taken the shooter into custody. The 5 soldiers who were shot were taken to the hospital, which at least on the surface implies that all 5 are still alive. So that is potentially good. So we'll keep an eye on it with the 20 minutes we have left. Let's go back to Louisiana. This guy's got a group behind him, so maybe this will be a good result.
And staff at Louisiana State Penitentiary, would you introduce yourself, please?
Deputy Warden Rochelle Ambo. Deputy Warden Ashley Olivo.
Reginald Admiral, classification.
Carmen Chipley, offender records.
Okay, thank you. And we'll call on you in just a little bit. And we have some people here that are observing this, and some people here that will be testifying on behalf of your effort, Mr. Craig, to be released. And we have people that are going to be testifying against your effort to be released that are here. And I see you have a number of people behind you. And of course, we will introduce them as they speak. I think that one of them there is going to speak, Miss Melinda House. Then Gerald Jackson is going to speak here in headquarters. And then Kerry Myers is Zooming in with Louisiana Parole Project, and he's going to be speaking. Before we do that and get into that, since we've had introductions, and this is our fourth or fifth case this morning, so we have formally opened our session. Before we get into anything else, that's all the procedural matters we have. So it'll go like this, Mr. Craig. I'm going to give you an opportunity to introduce yourself, give us your DLC number, and tell us exactly why you're there. Tell us what you've accomplished since you've been there, as far as that's going to help in your effort to convince us to parole you, and to give us a little bit of background on you. Then we're going to ask the facility there at Louisiana State Penitentiary to tell us what kind of fellow you've been there. Then I'll ask you some questions since the case was assigned to me. And then my co-workers here will ask questions, then we'll make our decision. Pretty simple process. So,
Yes, sir.
So Mr. Craig, the show is yours. This is your chance to try to convince us that you're worthy of being paroled early.
Yes, sir. My name is Jody Craig, number 92113. I've been incarcerated since December the 10th, 1979. Started out on a day where I had a drinking associate of mine that came by, and we went out on Highway 31 and started hitting a bunch of lounges and all of that. And drinking at that time in my life, it was kind of a void in my life. A bad decision that I'd made, and I started out, and for some reason, after we went to quite a few clubs, I stole a truck, got in the company truck that he had ridden in, cranked it up, stole it, and threw a ride in it. After I rode around and went to different various places, I threw a ride in the vehicle, and then one thing led to another. I ended up committing the crime of aggravated kidnapping and had Mr. Jim Rogers drive me to Bossier City. And then I had released him. I seen a couple coming out of the Ravana restaurant in Bossier City. Then I committed the crime of aggravated kidnapping on Michael Wayne Hardaway and Cynthia Baxter, and had them drive me on the interstate going toward Mississippi. And at some point around that area, I had made the decision to where I killed Michael Wayne Hardaway in Delhi, Louisiana, and had done it, and then continued to drive and was caught in a 10-car roadblock in Vicksburg, Mississippi, and had signed extradition back to Louisiana. And the impact of this crime, it was, over the years and all, I had really hit bottom. It was a time in my life, due to that decision, that it was really an irrational act. I'm the one that had made that decision and all that, but alcohol played a profound influence in it. I'm sorry for my crimes. I've tried to vocalize that to the victims that were impacted by this. And I've also, when I hit bottom and I came to Louisiana State Prison and finally ended up here after being convicted, I had really hit bottom. I didn't want any trouble. And due to the self-help programs they had right here at LSP, I became involved in the program of Alcoholics Anonymous, and it helped me to realize things about myself, what was going on in my life, a way that I could demonstrate, make amends, try to become a better person, and try to reestablish stuff to where I realized the accountability. Not only did I hurt myself and my relationship to God, I hurt various victimized families. I victimized my own family, society. And so due to the programs that they have right here, I was able to learn a lot about myself. I was able to be involved in so many self-help programs, not only the United States JCs, but Toastmasters, Alcoholics Anonymous, substance abuse. And even though I was denied parole last time I came before the parole board, life continues on. My relationship around 1995, I'm a convert to the Catholic faith. For many years in my life, I was agnostic, but I began to seek, and I found Jesus through the church and began to establish that relationship. And through that, I became very actively involved in it. And for many years, it's helped me out tremendously, become such a part of my life. And the board and all recommended more programs. I had no problem with that because these programs are really good. Continued with it. I have a lot of support, not only from the church, but my family and myself. And my plan is to stay involved with the church and also with various recovery support groups and try to get out there and make a difference through volunteering my time, whether it be with prison ministry or whatever. The board was right in that area and addressing that. And I just want to say that I'm a change for the better, and I'm grateful for everything that these programs have offered me to where I can realize, to where I can make those amends and become a better person in society at large.
Okay. Thank you. We appreciate those comments, and we will certainly take them into consideration when we make our decision. Is the warden or the deputy warden available in the room to talk to us, please, about the, yes, ma'am. Would you tell us what fellow he's been?
Okay, so Mr. Craig has great work ethics. He's a Class A trustee. He's very well mannered and cooperative with anything orders that he's given. He only had a total of 12 DB reports the whole time he's been here. The last one being in November 2002. He has taken 100 hours, substance abuse, anger management, victim awareness, and letter training, thinking for a change, celebrate recovery, which is a part of Alcoholic Anonymous. He's a member of Toastmasters and the JC, and his Tiger is low.
Okay. All right. Thank you very much. We appreciate that bit of information. Well, we'll move on now to Mr. Kerry Myers, who is on Zoom, representing Louisiana Parole Project. And what are y'all willing to do, Mr. Myers?
Good morning. Kerry Myers is the Louisiana Parole Project. We're here in support of Jody Craig's parole. We supported Mr. Craig through his clemency process and through his first hearing. As he stated, in many cases, people who get denied have two options. They can spiral, they can lose hope, or they can take that and the recommendations of the board. They can take it to heart and they can continue to improve. Jody has done exactly that. Jody has been incarcerated for 45 years. He's 68 years old. We certainly understand the needs of someone who's been incarcerated that long and at his age. Parole Project will provide him with transitional programming upon release. We'll take him into our program. He'll get a case manager, a mentor, directly to work with him. He'll become versed in technology, particularly in social norms, understanding simply how the world works today outside of incarceration. We'll provide him with all the support he needs to connect to any services, his medical. We'll continue to, we have already worked with his family. His long-term plan is already initiated his ICOTS to Texas, and that is his long-term plan to return to Texas once he completes a parole project. But we are prepared to work with Jody through this transition. By all accounts, during his 45 years of incarceration, Jody's been a model prisoner, hasn't had a write-up in 23 years, has availed himself to all of the things that prison has to offer him. He's no threat to public safety. We come before this board often. You see petitioners come before this board often. And in so many cases, the offense is difficult. They're all difficult. We understand that. Jody has done everything he can to become the person he is today. We believe that. That's why we've been with Jody since his clemency hearing, and we'll continue to support Jody. We'll ask this board to consider these factors today and grant his parole.
Okay, thank you, Mr. Myers. Thank you for the job that y'all do, the work you do, and thank you for your comments. We'll take them very seriously. We'll move on to Mr. Gerald Jackson, who is headquarters here. Mr. Jackson, would you tell us exactly what your relationship with is and what you have to say?
Yes, thank you. I appreciate it. My name is Gerald Jackson. I served as a volunteer chaplain in Angola for 21 years. In my last 5 years there, I was full-time chaplain. So I worked directly with Jody. Jody was my clerk in the chapel's office. And I guess over my last 5 years in Angola, I probably saw Jody more than I saw my family because I was there very often. One of the reasons why Jody was in that position, he was assigned to that position by my predecessor, Father Bernie Companion, is that Jody was extremely trustworthy. Not only was he competent in doing the job that we asked him to do, but we needed someone in that position that we could trust. We needed to protect the integrity of the chapel when we weren't in the building itself. We needed someone to be able to handle records properly. And everything that we asked Jody to do, he did it exceptionally well. He was extremely dependable, extremely responsible. Again, there was nothing I could ask Jody to do that he couldn't do. And in many cases, Jody knew me so well that he could answer my questions before I answered. The other thing that I asked Jody to do is to get very involved with our retreat program. During the course of the time that I was there, even before it started, I was there. There was a retreat program where high school juniors would come up to Angola, and we had like 26 different groups a year that would come up there on a Saturday. And Jody was one of my speakers. And the reason I wanted Jody to be one of the speakers is because Jody was able to talk openly about what he had done. He admitted what he had done. He had taken responsibility. He explained to the students the consequences of his actions, and also talked to them about being forgiven. And also, God's forgiveness and stuff like that, in relationship to his church and stuff like that. Very, very genuine, very, very heartfelt. I thought that Jody connected with the kid because he was so genuine in his message to them that he was very, very effective. Jody also had a strong family network. I've gotten to know Jody's family members since I've gotten to know Jody, and I feel very comfortable in the environment that Jody may be able to go back to. He'll have the support he needs. I'm coming up to you to mention to you that this is one of the most comfortable talks I've been able to ever give about somebody that I'm speaking for. Because I got to know Jody so well that I feel quite comfortable in where he is today. And again, I ask for y'all's consideration. There's no doubt in my mind that Jody will do well if he's given that opportunity, and I appreciate y'all's time.
Yes, sir. Well, thank you for your passion, for your faith, your passion for helping people, and your passion for him.
I appreciate it.
Thank you, sir. Okay. Now we'll continue with people that are in favor. The last speaker will be Melinda House, who is the sister who is at Louisiana State Penitentiary. Melinda, we can hear you from there, so you don't have to get up or anything.
Yes, sir. Thank you. Good morning. I am Melinda Craig House. I'm Jody's sister, and I'm here today to speak in support of Jody. Over the years, I've been coming to Angola since I was 15, and I'm so thankful that over those years of time coming that I saw for myself the desire and the willingness for Jody to change and turn his life around. And not only that, but so many over the years, every time we come visit, I have someone to approach us that always tells us what an exceptional inmate and what a good person Jody has become. And so that's not something that, we've asked for. They are willing to tell us about that. And even as close as last month, I had someone to approach me. And so I'm so thankful for the Christian man that he is today. Although, our thoughts and prayers have always been with the families that are so deeply impacted by all of this. And but I'm so thankful for all the things that he has done. He has an excellent disciplinary. He's been a trustee for over 35 years. His prison ministry faith, and not only the mentors that Jay Jackson and the current chaplain and others here, but also we have a great support in our community. There are two well-respected leaders in our community that own businesses for over family-owned businesses for 45 years, and they both are willing to give Jody employment. We have so many in our community have wrote in letters of support, and they're all wanting the best and wanting to be there to support Jody when he comes home. Our family, we have he'll be able to come home and have a loving and stable environment. We would like for Jody to continue with his prison ministry. I've reached out to even the local diocese and talked to the deacon there, and that's over prison ministry where we're from. And if Jody's granted today, he said he would look forward to having someone like Jody to come. And I know God has used Jody. He speaks on those retreats to the young people. He has helped so many here in Angola with helping them get their GEDs. I know God's used him here, and I know that he has such bigger plans for him if given the opportunity to come home. And I humbly ask you today if y'all would grant Jody's parole, and I appreciate your time.
Okay, thank you. You're a loyal sister, and we appreciate your comments. We'll take them into consideration. I would ask that everyone in the room there, starting with the man that is on your direct left, would you introduce yourself for purposes of the record, please?
My name is Thomas Key, Jody's cousin.
Okay.
Richard Craig, brother.
Okay.
Angelo Nola. Chaplain.
Thank you. Okay, behind you.
Michael Wagner, childhood friend. Grew up with the family.
William Messenger, chaplain here at Louisiana State Penitentiary.
Maria Messenger, volunteer chaplain.
Okay, thank y'all for being there in support of him. We appreciate that very much. Okay, we'll move on to those that are in opposition, and we have some that are on Zoom, but they will not be speaking. Mr. Cody Boyd with the Bossier Parish ADA's office, and I'm not sure if the Bossier District Attorney is here or not, is on Zoom or not, but I know he was interested also. Jason Parker, who is the Webster Parish Sheriff, he is on Zoom. Those that are here to speak are going to be Justin Lewis, who is the victim's nephew, and Representative Raymond Cruz with the House of Representatives. And so we'll start off with Mr. Lewis. Would you talk to us, please?
Good morning.
Good morning.
Young said that alcohol had a profound effect on him, led him to make some irrational decisions. He stated that Alcohol Anonymous and the Catholic Church has helped him change. I know many people who are drinking are alcoholics. It's profound in many of their lives and has made them all make irrational decisions. I don't know of any of those irrational decisions leading to burglary, robbery, kidnap, and murder. I pray the board will use the most stringent caution when releasing someone to a society where alcohol can be purchased on every corner to prevent more irrational decisions being made. I am sure victims' awareness is a fantastic force, but I think for it to be successful, the person would have to know who the victims are. When Jody went to the Rogers residence, he got out with 2 guns. I was at the Rogers residence Sunday. Mr. Rogers' daughter and daughter-in-law Melanie showed me where he went inside the house and jerked the phone off the wall where no phone calls could be made. He told them he killed someone in Kilgore earlier that day. He and another associate had been at bars since early that morning. They stole a gun at one bar and got into a fight at another. That's when he stole Ricky Black's truck and drove toward Tyler. He wanted to take Melanie, who was 7 months pregnant. He held his gun on her when Mr. Rogers entered the house and pleaded with him to take him instead. As they were leaving, Mr. Rogers' wife, Polly, drove up to the house. Jody told Melanie and Jim Rogers Jr. to tell Polly that they were going on a beer run. He told them if they told her anything else, he'd come back and kill them all. He held a pistol up to Jim Rogers' head several times on the way to Bossier. Mr. Rogers drove back roads all the way to Bossier and avoided the interstate. So it was a longer drive than it would have taken on the interstate. That's how they drove up in front of the Ravana restaurant on Highway 80. Jim Rogers Sr. suffered until the day he died and the trauma he endured that day. He had recurring nightmares for 13 years until the day he died. He blamed himself for Mike's death. Melanie is still scared to be alone to this day. Melanie Rogers, Polly Rogers, Jim Rogers Jr. victims of that. I'm glad he goes to church. My son said that even agnostics in the Marine Corps go to church on Sundays to avoid tearing down the whole platoon's barracks and putting them back together. The same can apply to prisoners. He was agnostic prior to going there. He said he couldn't come up with words to describe his actions that day. I decided to help him today by reading his words a year after this crime happened from the Richard Parish Public File. He said he was in a bar that morning and got an overwhelming feeling that he had to get out of there. He immediately walked out of the bar and stole a truck. He said he wasn't in control of his actions. Later that day, after the robbery and kidnapping of Tyler, he pulled into the restaurant in Bossier City, saw a young man and woman getting into the car, pulled a gun on them and forced them to drive him east toward Mississippi. He then recognized the man as Mike Hardaway. He began to feel very strange riding in the car. He became aware of having sexual feelings toward the woman, and he wanted to have sex with her. He had Mike drive off down the road near Delhi. When he got out of the car to urinate, he forced Mike out. When he was getting back in the car, he told Mike to step back. Then he had this strange, uncontrolled feeling to shoot Mike. The next thing he realized, he had shot the man. He said Mike made a noise and fell on the ground, flopping like a chicken. I don't know if I felt remorse or something, if I would describe it that way a year later. I believe I would probably hit that, flopping like a chicken. I think I would have. I'd like everyone to know that that wasn't the end of Mike. He shot him 200 feet from a highway down an old gravel road and then sped off in the car like a coward. With bullets tearing through almost all of Mike's vital organs and shattering many bones in his body, he crawled on his hands and knees all the way to the highway yelling for help. That's where all the scars came from that were on his hand in his casket. A man named Pat Patterson, nearly 300 yards away, heard him yelling after the gunshots and went to see what the problem was. When Pat got there, Mike was dying. Before he faded away, he was able to tell him who Jody was and that he had Cynthia and he was taking her toward Mississippi. Mike began to fade as he mentioned his mom and dad being older and his dad not doing well. He died moments later. Pat Patterson was a victim also. He cries till this day over Mike's death, wishing that there was something he could have done. If I had more time, I'd go into details. When Mike's belongings were returned to his parents, the police advised them not to take the clothes he was wearing that night because they were way too blood-soaked. Mike was a hero that day. Jody was a coward. In closing, I've watched several of these parole hearings, and I hear people say everyone deserves a second chance. Does second chance mean third chance? Does second chance mean fourth chance? I'd say our first chance is given to us between the ages of 16 and 18, old enough to know right from wrong. I believe he got a second chance at that age when he got drunk and disorderly. I believe he got a third chance with a drug possession charge, and I believe he got a fourth chance with an assault on the law enforcement. But let's dismiss all those. The only thing he gave Mike was death. Law enforcement gave him a chance to surrender on the bridge. In his words, as soon as he saw the roadblock, he automatically put the gun under the seat and raised his hands and surrendered. Warren County Sheriff Paul Barrett figured there'd be a gun battle and had 18 lawmen set up on the Mississippi side of the bridge. They gave him a chance to live. He was given another second chance when he pled to second-degree murder and kidnapping. He was given 2 life sentences. He was charged with first-degree murder, but that comes with the possibility of death penalty. He decided to make a deal to go to prison for life without the possibility of parole to avoid the death penalty. Now, he wants another second chance. Parole wouldn't be a second chance. It wouldn't be a third chance. Jody Craig told Jim Rogers Jr., Jim Rogers Sr., Melanie Rogers, Mike Hardaway, and Cynthia Baxter that he would not be taken alive. He stated that if they got him, he would take them with him. He made good on that statement 6 hours after he took Mr. Rogers. I think he would have sobered up by then. That's why I think it needs to be extreme caution to let someone out where alcohol can be purchased on every corner. In his clemency hearing and parole hearing, Mr. Wise asked Jody if he killed him because he knew him. Jody stated that's not the reason that he killed him. He told Bonnie Jackson the same answer in his last parole hearing. He didn't kill any of the Rogers. He didn't kill Miss Baxter. He killed Mike. The only thing standing between him and sexually assaulting Miss Baxter was Mike. Jody says there was no reason that he killed Mike. In his own words, he wanted to have sex with Miss Baxter. That's never been brought up here. That's never been brought up when it comes of what he did that day. Jody's family owned a dairy farm on the Mike Pope Road in Shawmulu. It was located a quarter mile down the road from where Mike and his family are buried, including my father. His family would give bull yearlings to Mike's family each year. Jody spent the night with Mike at his house. They knew each other.
Mr. Lewis, would you kind of wrap it up, please? So I think
Yes,
we got just what you wanted to say.
Yes, sir. This is the last paragraph. When y'all voted communing his sentence, y'all told me this wasn't a vote to turn him loose. You said you heard me when I spoke how this destroyed Mike's parents. You said, we hear you now, and I told you Mike's daddy cried every day, all day, until the day he died, December 25th, 1979, 14 days after on Christmas morning. The doctors told everyone that he died of a broken heart. Taketsubo Carter, he wasn't diagnosed in 1979. He was diagnosed in 1990. It's broken heart syndrome, very real thing caused by grief. My family has always felt like he killed 2 people that day. I could go on, but I'm not going to. That's my point. It's his decision to get life in prison without the possibility of parole to live. He chose that. Thank you.
Thank you, sir. We appreciate those comments. I know they're heartfelt and for your family. Sorry about what you've gone through. Representative Raymond Cruz, sir, would you tell us what's on your mind?
Thank you, Sheriff Rader, and the rest of the board and everybody that's attending today. I just heard about this case recently. I represent Bossier Parish where this occurred. And it was brought to my attention that this parole hearing was being held. I can tell you, I can't think of much more than Mr. Lewis said in terms of why this shouldn't be granted. I actually support Jody. I do. Or Jody. But not for his release. I support him to be incarcerated and continue in that manner. I wear socks today. The state of Louisiana says union, justice, and confidence. And the citizens of the state expect justice and confidence. And I think granting this parole would do the opposite. We need the people to know that we're looking out for them and we're executing justice the way it's needed. When I read the string of events and all the prior times that Mr. Craig has been on the opposite side of law enforcement, I saw a pattern. When I looked at his apprehension over in Tyler of his first victim there at about 5 o'clock and realized the time it takes to drive today on the interstate to Vicksburg is 5 hours, 4 hours. But on the back roads, whatever, it's many, many hours. So I'm thinking he had plenty of time to think about what he's doing, what the consequences of this would be. And I believe he's got all the chances he needs to be able to be released and that it's haven't been granted. I don't think they should. I do think that for everything we do, there's a consequence. And unfortunately, the consequence for him is continued incarceration. I think that's best for the people of Louisiana. I think that's best for the families that have been impacted. But I think that is what justice is. Many times we suffer things from our decisions, and there's just no way around it. And I'm afraid that needs to continue in this. So I appreciate y'all giving me the time to speak. I was amazed at how much the internet has not done for us yet, because I researched this on the internet for several hours. We don't have all these records recorded. So here's some of those documents from Richland Parish were eye-opening, even further to me. I thought on the evidence that I had just from the arrest records, whatever, exposure, and the police there, that was reason enough to keep them incarcerated. But after hearing all the details, I'm convinced that people in the state would want to see continued incarceration in this. Sorry for the family that this has happened in their life and the Craig family, but I'm even more sorry for the victims of this continued series of crimes. And I would appreciate that y'all give a strong consideration to denying this parole. Thank you.
Thank you, sir, for taking time to come and talk to us, and we will take all of those seriously, okay? Mr. Craig, this case has been assigned to me, and it's, I don't think anybody else is going to speak. Hold on just a second, Mr. Craig. No one else is going to speak, correct? Okay. All right, that's all that will be speaking. I've already identified and introduced them. Everyone else that's on Zoom that we're aware of. And so, anyway, it's my, as the interviewer, as the lead on this thing, I'm supposed to ask you questions. I don't have a lot of questions about the crime, but, and I don't have a lot of questions because we've had so much extensive, coverage as far as support and as far as being against you. I've read the file, several hundred pages of the police reports and the file and all that. And we all know how egregious the crime was. And also, I don't have a lot of questions to ask. In fact, I have no questions. Miss Jerry, do you have, Miss Ledoux, do you have any questions that you'd like to ask?
No, I've read it all thoroughly. Thank you.
Do you have any questions that you'd like to ask, Mr.
No, just that the young man that was killed was only 23 years old. I read that. And then they had two funerals in 2 weeks because the dad died, like you said. And I do know they have documented broken heart syndrome. So all of it's sad.
Okay. All right. I think everybody's got all the questions. You said what you need to say. We've heard for the pros and the cons. And so it's time for us to make a decision. It's my responsibility to be the first one to vote. And it takes a unanimous vote to grant your parole. And having studied the case extensively, and we all agree, even you agree how heinous the crime was. And so my vote is, I want to tell you how proud I am of your accomplishments and all that, but at some point there has to be consequences. And you pled to the sentence that you got. And so I feel like that's what you need to serve this particular time. And so my vote is to deny your request for a parole. Ms. Stapleton?
I concur with Mr. Prater for the same reason. You pled, made a plea bargain, and the crime was very heinous.
Okay. Mr.
Craig, 21-year-old who does this, you've served 45 years. You've done so many good things. Today, my vote is going to be to deny, but I see that you've done what you need to do. You're doing the things you need to do. Okay. So my vote is to deny that.
Okay, Mr. Craig, I'm sorry to tell you, but your parole has been denied this morning. The time is 10:09. That's the end of this hearing.
Denied.
I don't know about you guys, but honestly, mixed feelings on that one. But we don't sit on the board, so it's up to them. I think that's it for today. We went 15 minutes into overtime. I hope you all had fun. I know I did. We'll be back live tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. The show went so fast today, and there was so much going on. I never found a good time to call out our sponsor, Aura. But please do check them out, aura.com/TCF. There is a link down in the description. I've arranged for all of you to have a 14-day free trial. I don't recommend any product that I don't use myself. They are worth it, so please use the link down in the description, aura.com/TCF, and check them out. They have done a wonderful job getting my data removed online, and I would encourage you to give it a look. But again, anyways, we'll see you tomorrow. Go have yourselves a great Wednesday. Make the most of it, and take care. God bless.